We good to go?
Yes.
All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, January 27th. We have two bills on the docket today, Senate Bill 53 and Senate Bill 165. Both are from Senator Carter. So we'll start off with Senate Bill 53. Senator Carter, the floor is yours.
Thank you. Thank you, Chairman Smith. And it's a pleasure. Listen, first of all, I want to thank all of the members of this committee for your endurance. Once again, still early in session to have quite a robust and long briefing prior to this hearing. Please don't hold it against me. I promise to keep my testimony brief, my part of it. But so I have two important bills that stem from the overall desire to make improvements in our juvenile justice system and how we treat children in Maryland. First, I'd like to incorporate by reference the testimony, the heartfelt testimony of Keisha Hogan in the briefing and the compelling testimony of Jenny Egan in the briefing that we just had. This bill is what I would consider a no-brainer. It really ought to be a no-brainer. It's the third year that I've brought the bill. It's not received a vote from our committee before, so we haven't actually ever shot it down. I say it's a no-brainer because we all know that our Constitution guarantees persons the right to an attorney in a custodial interrogation, but we have carved out an exception when it comes to the most vulnerable among us, our children. And so all this bill does is ensure that children would have access to a consultation with an attorney prior to a custodial interrogation. And I want to stress, we're talking about a custodial interrogation. We're not talking about a general broad investigation, talking about what the law recognizes as custodial interrogation, which is one of the stages of the criminal process. And also, it's an extension of a bill that I passed, I think, back in 2012, where the intention of that bill back then was to ensure that children had their parents notified when they were taken into custody and questioned by police. And it wound up not being strong enough because it gives too much discretion, and too often that's still not happening. I had a prepared written testimony, and I won't go through it because the day is long, but I just want to point out a couple of things from it. And you can certainly refer to the written testimony that's submitted. But I had in my written testimony, what we heard earlier today in the briefing also from Jabria Handy, who was charged as an adult when she was just a child for a murder. And you heard that compelling testimony. And what this bill will do is help to prevent situations like Jabria Handy's, where she was the victim of some coercion. We also have 14-year-old Devontae Stanford from Michigan, who admitted to a quadruple homicide that he did not commit after being arrested in his pajamas and interrogated for 24 hours without either a parent or an attorney present. He confessed because the police told him that if he did, he could go home. This is very common. Or 16-year-old Brendan Dassey from Wisconsin, who confessed to a murder his uncle actually committed because the investigators, in his words, got into my head. This is all too common. Last year, when I presented this bill, and I don't know if anyone else is planning to present it, I presented a video, and I'm happy to share that with the group. In the interest of time, I'm not going to show it this time. Presented a video of a youth being interrogated by law enforcement, and you could see the example of this unresponsive, scared kid in a cold, dark room being interrogated by adults. You could see he was visibly afraid and probably didn't even really know what was going on. All we want to do is make sure that young people understand what is happening to them and understand what is before them with respect to the criminal process. And we want to just do the decent thing and notify the parents, as any of us that are parents would want to have happen if our child is taken into custody. And so with that being said, and for those reasons, please listen to the testimony with an open mind and open heart. And I would, for those reasons, urge us to vote favorable on this bill. Thank you.
Excellent. Thank you very much, Senator Carter. We'll now turn over to your panel, and then after we'll open up for questions from senators. First up, we have Ms. Egan. Where are you? I saw you. There you are.
Thanks. Like Senator Carter, I'll try to keep my statement extra brief. I'd like to cede any extra time I have to Laura Nylander, who's an expert on this issue and can answer a lot of questions. I'm here to support this bill. It's one of the top priorities for the Maryland Office of the Public Defender because it has broad implications and impact on the children that we represent. It's simply the right thing to do in a time where our history and fellow states are replete with laws and judicial recognition that children under 18 cannot be viewed simply as miniature adults. It's time for Maryland to start taking heed and protecting their legal rights. This bill is about making sure young people have due process and access to due process. This bill aims at legal protections to ensure that legal protections are implemented and upheld for children and adolescents subject to custodial interrogation, understanding that children and adolescents are fundamentally different from adults means that they should not be treated or viewed as adults when it comes to a Miranda warning, whether they are 7 years old or 17. This bill will codify existing legal protections for children under 18 and make sure that they understand and accept the dangers and risks of custodial interrogation and giving up their Fifth Amendment rights. This is especially important when we see traumatic news coverage of young children being handcuffed through tears and temper tantrums, thrown to the ground or physically assaulted or restrained, pepper sprayed or tased, shot and killed. The United States has a sordid history with children and adolescents in the criminal justice system, particularly Black children. Today, we have a desperate need for reform and reckoning with how children are treated in that system. The question at stake is not one of guilt or innocence, not truth or deceit, right or wrong. It's about making sure that kids understand what their rights are before they give them up. We know that 90% of children give up their Miranda rights, and most of them self-report that they don't understand. They either didn't understand what it meant, or they didn't want to upset the authority figure who was reading it to them. I'll cede my time. Excellent.
Thank you very much. All right, next we will now go to Ms. Nylander. I think I saw you populate up. Okay, there you are. Excellent. You're up. Welcome.
Thank you very much, Senator, and good afternoon. My name is Laura Nylander. I am a practicing wrongful convictions attorney and the co-director of the Center on Wrongful Convictions here at Northwestern University. As a lawyer, I've worked to exonerate dozens of innocent children who confessed to crimes that they did not commit. And for 15 years, my colleagues and I have studied why children give false confessions at the rate they do. The answer has everything to do with the fact that standard psychological interrogation techniques rely on deception. They work by making a child think he's trapped and that confessing is the only thing that will help him get out of trouble, even if that's not true. Without the guidance of a lawyer, children under 18 are not equipped to see through this deception or to make the high stakes decision to confess. That's why research shows that kids are between 2 and 3 times as likely to falsely confess to crimes they didn't commit as adults. You know, the problem of false confessions is one that Maryland children have lived. In 1998, Cecil County resident Alan Chesnut was 16 years old when his neighbor was stabbed to death. The police had almost no leads to go on, so they brought Alan in for interrogation without a lawyer. During that interrogation, they accused him of the murder, and they falsely told him that his DNA was at the crime scene. Eventually, Alan agreed to say that he did it. Later, he explained, I thought that if I just told them stuff, they would let me go. Instead, Alan spent months in jail before DNA from the crime scene identified the actual perpetrator and prompted Alan's exoneration. His mother described this whole ordeal as pure hell. You know, Maryland has a long and honorable history of adopting laws that are meant to protect kids like Alan from the dangers of unguided decision-making. If you're under 21, you can't buy cigarettes or own a handgun. If you're under 18, you can't get a driver's license, sign contracts, or even use tanning beds. It's time to apply that thinking into the interrogation room. We need to protect children from undergoing interrogation without a lawyer, and this bill is a necessary step to protect against false confessions. Thank you.
Excellent. Thank you very much, Ms. Nylander. Next, we will have Mr. Mendoza. There you are. Welcome.
Dear Chairman Smith and honorable members of the committee, on behalf of the Anti-Recidivism Coalition, we thank you for this opportunity to be able to testify in support of SB 53, the Childhood Protections Act. The Childhood, I'm sorry, I'm a little nervous. The Childhood Protection Act. ARC provides direct services to people who are currently and formerly incarcerated. We also provide a reentry service program upon reentry and opportunities to advocate for policy change. In 2020, California passed a law requiring youth under 18 to consult with an attorney before waiving their rights. The legislation was passed with bipartisan support while recognizing that these protections make our community safer. Both Democrats and Republicans took into consideration testimony from San Francisco District Attorney Chesa Bodine, who testified in support, stating that these protections have not diminished his office's ability to prosecute serious and violent crimes. I spoke with a DA from his district attorney's office just this morning, who still holds that to be true to this day. Our very own board member, Jerome Dixon, at 17 years of age, was interrogated for 25 hours until he falsely confessed to a crime he did not commit. He did not get to go home until 21 and a half years later, after the California Board of Parole hearings recognized his innocence on record before his release. While he was innocent at 15, I made the worst decision of my life by participating in a gang-related murder that took the life of an innocent young man. Until, by the grace of God, policy saved my life and allowed me to prove that I wasn't that 15-year-old kid anymore. But I will never forget my arrest or interrogation, nor will I ever forget the life that was taken that day. However, this bill is about allowing our youth to understand their constitutional rights so we can ensure the outcome of interrogations are not only just and lawful, but create greater trust and accountability due to process for all. For these reasons, we support this bill and respectfully urge this committee to issue a favorable report. Thank you.
Thank you very much, Mr. Mendoza. We will next go on to former Secretary of Education, John King. Is Mr. King here? Here we are.
Yes.
Welcome.
Thank you. Thank you, Chairman Smith, and thank you to the members of the committee. I'm here testifying as a former teacher, a former principal, a former Secretary of Education for President Obama, and advocate for education civil rights. When I was a teacher, I would talk to my students about the Fifth Amendment and its importance in our history, the importance of due process, the idea that the founders cared deeply about human dignity being protected in the Bill of Rights. But sadly, the interrogation of children without legal counsel contributes to the school to prison pipeline and appalling racial disparities in youth justice in Maryland. I've seen as an educator, young people get caught up in the criminal justice system and have the trajectory of their lives change because they didn't have access to due process. I myself struggled as a kid after experiencing the trauma of losing both of my parents. I got kicked out of high school. I'm only alive today because of the second chances I got. I know how important it is that we protect our vulnerable students. As Senator Carter described, the evidence is clear that young people disproportionately are likely to make false confessions. They are likely to not ask questions about their rights. We have much to do in policing reform and addressing issues of criminal justice in this state, but we can start with delivering on due process. It's a matter of simple fairness. And for that reason, I urge a favorable report on Senate Bill 53.
Excellent. Thank you, Secretary King. Good to see you in JPR. All right. We'll go on to, someone has a hot mic here. Just want to make sure they're not a senator, is it? Make sure you're good. All right. We are now going to go on to Ms. Chaudhary. Ms. Chaudhary, I thought I saw you there earlier. There you are. Welcome.
Thank you so much, Chair Smith and members of the Senate Judicial Proceedings Committee. On behalf of CARE, I thank you for this opportunity to testify in strong support of Senate Bill 53. CARE is America's largest Muslim civil rights and advocacy organization. When police take someone into custody, they're required by law to read them their Miranda rights. However, these rights don't apply to individuals who are questioned without being officially taken into custody. And the circumstances are drastically different when minors are taken into custody versus adults. Children are less likely than adults to be able to understand the complex legalities involved with submitting to questioning by police. Studies show that children are also far more likely than adults to make false confessions. One study of exonerations found that 42% of exonerated juveniles had falsely confessed, compared with 13% of adults. As proven by the Central Park 5 case, uncertainty, intimidation tactics, and coercion in the absence of a parent or attorney, as well as environmental and personal factors, can induce fear and compel a child to misspeak. This compromises due process, it leads to serious consequences, it hinders justice, and can irrevocably alter these children's lives. Children of color are disproportionately over-policed. They are far more likely to suffer adverse consequences and become entangled in the criminal justice system. Loopholes and tactics in the policing practices further erode trust. It's a fact that some police departments use questioning techniques that are designed to elicit confessions. In JDB versus North Carolina, the Supreme Court was asked to decide whether the age of a child subjected to police questioning is relevant to determination of being in police custody. In that case, a 13-year-old 7th grader was escorted from his classroom by a uniformed police officer and questioned about his knowledge and involvement in a string of neighborhood burglaries. The boy's parents or attorney were not notified or present. He confessed and was released by the officer, then later charged by the state of North Carolina with breaking and entering and larceny. In a 5-4 decision, the Supreme Court held that Miranda custody analysis includes consideration of a juvenile suspect's age, specifically whether a child's age would have affected how a reasonable person in their position would perceive their freedom to leave. The Supreme Court ruling that a child's age is relevant in the determination of their being in police custody because of a perceived power imbalance, preventing them from walking away on their own free will, is all the more reason why parents, guardians, and attorneys should be notified before the questioning of minors. We strongly support this bill, and we urge you to give a favorable report. Thank you for your consideration.
Thank you, Ms. Chaudhary. Good to see you. We will now move on to Judge Kroom, or Mr. Kroom. Hold on one second. Let me get you here.
Chair Smith and members of the committee, let me initially say that I am not speaking as an official representative of the Maryland courts, but for Maryland Alliance for Justice Reform. That said, I'm bringing, in my view, experience since 1991 as a juvenile magistrate and since 98 as a juvenile court judge. I can say that SB 53 would not throw our juvenile courts into confusion or disarray. It would clarify what the rules should be as to interrogation of juveniles by creating presumptions that there must be an attorney first before questions are asked, and that if that's not done, that the statement is not admissible. It strongly is supported, I think, by the studies, including a 15-year study from 89 through 2003, that juveniles are 3 times more likely to give false confessions when interrogated by police than adults would be. And for that reason, supporting Major would also suggest that the committee consider an amendment, a friendly amendment, to also provide that in interrogating juveniles that police may not use deception. This is an amendment to juvenile law that has been made in Illinois, Ohio, Oregon. It's under consideration in Nebraska, New York, and in the United States Congress. It is not a shocking or unreasonable proposal, and in fact would go a long way to prevent the false confessions that police may elicit, perhaps not even intending to do so. I will cede the rest of my time and again strongly urge the committee to support SB 53 and possibly an amendment to also prohibit deliberate deception by police.
Thank you, Mr. Kroom. I'm looking through your testimony. There's a lot here today, but is the amendment language or just in concept in your testimony?
I did not submit written testimony. Other members of our group have. I would be happy to submit the language that comes from Illinois, Ohio, and Oregon. I'll send that to Senator Carter.
That'd be much appreciated. Thank you very much. All right, next we'll move on to Mr. Oday. Mr. Oday, there you are.
Thank you, Mr. Chair, members of the committee. We appreciate your time today and hearing these bills. I'm Garrett Oday, for the record, with the Maryland Catholic Conference. Here in support of SB 53, the Child Interrogation Protection Act. So you're going to hear from us twice today, so I just want to take a minute to mention the support of the Maryland Youth Justice Coalition for this bill. We're a conglomeration of Maryland organizations, the Public Defender, Strong Future Maryland, our faith-based partners in Bridge, Maryland, as well as a bunch of national experts and groups such as Human Rights for Kids, R Street, and the Sentencing Project, who all support these two bills today. On this bill, I'll just offer that if you believe in due process rights, we believe in the consistency of our constitutional protections that children should be afforded here. And why not take steps to ensure that youth are not afforded the right to an attorney at interrogation? And yeah, California, Virginia, Illinois, they do better than us on this, but also so do North Dakota, Kansas, North Carolina, and Oklahoma. So politically speaking, I'd submit that this is not a partisan issue. It's not a progressive or conservative issue. It's a constitutional issue and a due process issue. Lastly, I'll say that we're concerned that parents are not receiving actual notice of their child's situation when taken into custody. So the family unit is the bedrock of our society, and that's what we believe. And it's not much to ask that our state tighten up the notice requirements to ensure that parents are provided parents are involved in the process when their child is taken into custody and interrogated. So thank you very much on behalf of the Maryland Catholic Conference and our Maryland Youth Justice Coalition for hearing us today.
Excellent. Thank you very much. Is Ms. Tavares, Denny, are you still up? Are you up? There you are. Are you there?
Yes, let me get cute.
Gotcha. There you are.
Give me a minute. Give me a minute.
No worries. We're good. Good
Good to see you guys. Good to
Likewise.
see. Let me get cute and bring up my stuff. Hold on.
Take your
time. Good afternoon and Happy New Year, everybody. Chair Smith and members of the JPR Committee. I am Prince George's County Council Member Denny Tavares. Last year, Maryland sent more kids to adult court than California, Pennsylvania, Massachusetts, and Arizona combined. 81% of those children who are Maryland residents were Black. 97% in Prince George's County were Black and Latino. The amount of children in Maryland sent per capita based on offensive type to adult court is more than any other state except Alabama. And I ask for your favorable support of SB 165. Because this bill will ensure that kids start their cases in a trajectory in the juvenile system, which has a smaller caseload, greater access to rehabilitation, and a closer collaboration with families and schools. If sent to adult jail, this environment for a child is detrimental. A young person will have difficulty in receiving the medical assistance and treatment that they so dearly need, and will experience extensive trauma that can also trigger past abuse through strip searches, sexual abuse, bullying, and be 3.6 times more likely to recidivate. And let me share a story of why I think this is so important. And I'll share a story about Romeo from my district in Prince George's. Romeo is a 14-year-old middle school student who allegedly killed the taxi driver. He grew up in an abusive and alcoholic father who also abused his wife, Romeo's mother. Growing up, Romeo's mother was depressed, suicidal, and disengaged, which clearly has an impact on any child. Once Romeo was older and acting out and going through his own mental health challenges, his mother tried to get him help, but couldn't place him in a residential program or intensive mental health treatment because none existed, and she also was someone of limited means. Hello?
Yes, that's just our makeshift timer here. So
okay, so I'm almost. Can I just?
Yeah, yep. Go ahead.
So Romeo was placed in jail for almost an adult jail for almost a year and he had never received any prior mental health support and limited treatment. And access to his mother. Once he was finally in juvenile system, he was able to get all of that. As a public servant who has to deal with the ramifications of your decisions and the effects that it has on the life of returning citizens, I ask you to take an empathetic look at these children like Romeo to give them an opportunity for a chance to rehabilitate in a safer environment. We can either build a Romeo that's constructive, a citizen and a mentor to teach other children like him not to follow in his footsteps, or we can grow a hardened criminal that potentially will be impossible to reform after what he's been exposed to and experienced in an adult jail. We don't, at the end of the day, hold on a minute, I just want to close.
Bring her home.
I just want to say, and I don't come to this decision lightly as an individual whose father was a taxi driver and was killed on the job, but I do ask for your support for children like Romeo. So I seek your favorable support of SB 165. Thank you.
Got it. Excellent. Thank you very much. All right, next we'll move on to Mr. Drison, and then we're going to go to Ms. Stoutmiles. So just you're on deck. Mr. Drison, you're up. It's going to ask to unmute you. 1 second here. To switch over to your screen and unmute. Here we go. There you go.
Okay. Thank you and good afternoon. My name is Steve Drison, and I'm the co-director of the Center on Wrongful Convictions at Northwestern Law School. And over the past 25 years, I've represented dozens of teenagers who gave up their Miranda rights and were then coerced into confessing to crimes they did not commit. I dedicated my life not only to preventing false confessions, but to ensuring the children in police custody have the protections they need to understand and exercise their constitutional rights without being pressured to do so. But children often lack the judgment that is needed to give up these rights, and every parent knows this. And when children are under stress and police interrogations are extraordinarily stressful, even children who know better will often say anything they think the police want to hear just to relieve the stress. What's more, a recent study of 12 to 19-year-olds showed that 69% didn't fully comprehend their rights. And the right that they understand the least is often the right to counsel. Too many kids think, for example, that an attorney is required to tell the judge everything that they discuss with them. And sadly, police officers do little to make sure suspects understand this precious right. They read the rights in rapid fire fashion. They do nothing to test for comprehension, and they encourage kids to give up their rights, often saying things like, only the guilty hide behind lawyers. Because so many kids can't adequately protect themselves, we're starting to see states, and you've heard some of them, California and Illinois are the two leading states, that now require that some children consult with attorneys before interrogation. And that's why it's time for Maryland to follow suit. And the key there is attorneys. We know that parents alone aren't enough to protect kids. And many parents themselves don't understand what the Miranda rights mean. And too often they are co-opted by police to serve as interrogators of their own children. Constitutional protections for children are nothing more than empty promises if they are routinely ignored by parents, by the police, by the courts, and by kids themselves. It's time to honor our promise of greater care and protection to children. And I hope that this committee will enact Senate Bill 53 in that spirit. Thank you.
Thank you very much. All right, now move on to Ms. Stoutmiles.
Good afternoon, Mr. Chairman and members of the committee. Thank you for the opportunity to support Senate Bill 53. I'm the state policy advocate for Juvenile Law Center, and I'm a member of Montgomery County's Commission on Juvenile Justice. I'm testifying in dual capacity to urge the legislature to support this bill and protect the vulnerable youth in our state. I have 4 points I'd like to present. Number one, a couple of examples of this current practice in action. In Maryland in 2019, there were 2 instances of police questioning elementary school children for playing with play money. Their parents were not notified until after the police asked the children questions and Secret Service was called. Even when questioning does not lead to an arrest, the potential trauma of these interactions for youth is significant. 2, the protections in this bill are vital. It's so good because it is our opinion that Miranda itself and an attempt at contacting a parent or guardian just isn't sufficient protection for youth. The bill provides the protection of consultation with legal counsel to ensure the child's legal interest is protected. 3, children should not be expected to understand concepts like their rights. Even if the police gave Miranda in perfect fashion, and even if they taught kids all about Miranda, kids will still not fully appreciate the warnings because 1, the warnings are too abstract, and 2, the kids are under stress and in a moment of hot cognition where they are not making the most measured decisions. That is why it is so important that kids have counsel. 4, children are susceptible to coercion and false confession. Gaining a false confession by interrogating children without counsel enables the actual predators to wander the streets. The likelihood of a false confession is too high to forego the procedural safeguards. If we wish for Maryland to have a fair and equitable justice system, we must ensure that youth aren't coerced and incarcerated simply because they are children and don't understand their constitutional rights. The Juvenile Interrogation Protection Act would better protect children's rights and better meet their needs. For these reasons, we urge the legislature to pass Senate Bill 53, and we thank you so much for your leadership.
Excellent. Thank you very much. All right, now we'll move on to Dr. Tilghman and then Ms. Atkins, you're on deck. So you're both from the same organization. So Dr. Tilghman.
All right. Good evening, everyone.
Good afternoon.
Yes, again, my name is Reverend Dr. Marlon Tillman, and I thank you, Chair William Smith and Honorable Senate Judicial Proceedings Committee. On behalf of Bridge, Maryland Incorporated, we are in favor of Senate Bill 53, Child Interrogation Protection Act. We represent several of the legislative districts on this committee and throughout the state, and we want our most vulnerable population in Maryland to be protected from interrogation that could scar them for life. We want our children, grandchildren, nieces, nephews, and the next unborn generation to feel comfortable in the custody of police officers. We feel that it's reasonable that these details be shared with you in my testimony, and therefore I would simply be brief. We want SB 53 to pass because our members of over 7 faith traditions feel it's our moral imperative to protect children and youth from the risk of emotional, cultural, and situational trauma that could impact them in their adulthood. Our sacred text in the Talmud says our children are our grantors. Our sacred text tells us in the Torah that children's children are crowned to the aged and parents are the pride of their children. Our sacred text tells us from Jesus the Christ that, see that you do not despise one of these little ones, for I tell you that their angels in heaven always see the face of my Father in heaven. We support Senate Bill 53 because it is a reasonable request to notify a parent or guardian that their child is in custodial interrogation. It is a reasonable request and due process that a child or youth hear and understand Miranda that is spoken to them. It is a reasonable request that an attorney be present for a child before they even speak a word while in custodial care. So I close with a quote in an event I'm currently attending in Ohio by a noted author, theologian, and expert on trauma. Dr. Terry Shaw says this: children are good recorders of trauma, but poor interpreters of trauma. Why should we put our children at risk of an event that could scar them for life when we can protect them from it? Bridge, Maryland, a member of the Maryland Youth Justice Coalition, urges you to vote in favor of Senate Bill 53. Thank you for my time.
Excellent. Thank you very much, Doctor. All right. Is Miss Atkins here? Sandy, I'm not seeing Miss Atkins. Is she in the waiting room?
I don't see her.
All right. We'll move on quickly then to another representative from Bridge, Maryland, Dr. Venable. Dr. Venable here?
I don't see him either.
Okay.
Sorry.
It's
Her.
okay. All right, we'll then move on to Miss Ramsey, Debbie Ramsey. There you are. Welcome.
Thank you. I'm here to represent my own views as a retired detective from Baltimore Police Department and the speaker of the Law Enforcement Action Partnership, LEAP. This legislation is important to me because of my experience working with community members and children. In addition to my public safety career, I'm also the founder and executive director of Unified Efforts in West Baltimore, an out-of-school time violence prevention program that provides in-school activities and programs to children at no cost to their parents. So juvenile justice is an issue that is near and dear to me. I am speaking personally to support SB 53 and HB 269. It will positively impact police community trust. Interrogating children without giving them access to proper protection, such as having an attorney present, the families of the children and the community will feel that the police are taking care and not taking advantage of them. As a detective, I quickly learned that police community trust is essential to public safety. I'm a survivor because my community took care of me. Research shows that the brain region that controls corrective behavior in social situations is not fully developed until age 25, and even later for the male brain. Either you have a child or children, or you remember being a child. Do you ever remember getting your hand caught in a cookie jar? In summary, due to my experience with juveniles and public safety, I believe that the proposed bill, SB 53, HB 269, will strengthen police relationships with the community. Juvenile children interrogations through distress in the communities. We need to protect and serve. It's time to invest in prevention instead of punishment. Thank you. Debbie Ramsey.
Excellent. Thank you very much, Ms. Ramsey. All right, next we'll move on to Mr. Kokuka. Is he here? Oh, there you are, Doctor. Oh, one more time. Here you go. There you go.
Thank you. Good afternoon, Mr. Chair, members of the committee. My name is Dr. Jeff Kokuka. I'm a tenured associate professor of psychology at Towson University, and I specialize in the scientific study of wrongful convictions. Earlier today, Ms. Chaudhary mentioned the Supreme Court case of JDB versus North Carolina, in which the Supreme Court left no doubt that, in their words, children cannot simply be viewed as miniature adults. As a psychologist, I can tell you that the scientific evidence clearly indicates that adolescents are cognitively, socially, and neurologically different from adults in ways that impair their legal decision-making. With that in mind, I firmly believe that the safeguards provided by SB 53 will benefit the administration of justice. And in fact, this is my third year testifying in support of this important bill. In the past, opponents of this bill have argued that the standard Miranda language is easy to understand because they themselves can understand it. But as Mr. Drison explained, the science tells a very different story. Research has consistently found that juvenile defendants often forego their constitutional rights simply because they lack the necessary vocabulary to understand and invoke them. Accordingly, the American Bar Association has urged legislatures to support the use of simplified Miranda language with juveniles, citing an example that was written at a 4th grade level. Past opponents of this bill have also claimed that a child's physical maturity reflects their psychological maturity, but that simply isn't the case. Relative to adults, juveniles are more vulnerable to social pressure, especially from authority figures. And as Ms. Ramsey just explained, their underdeveloped brains often lead them to make short-sighted decisions. The same impulses that lead teenagers to engage in drunk driving or unprotected sex also render them more likely to make false statements or even false confessions, as Ms. Nylander explained earlier, which derail criminal investigations by leaving the true perpetrator free to reoffend. I would echo Mr. Oday's sentiment that these are common sense reforms that are nonpartisan and, as other states have demonstrated, very easy to implement without consequence. So in my view, this bill represents a vital opportunity to base our state policies on scientific evidence rather than on intuition or anecdote, and thereby improve public safety. I therefore urge your favorable vote on Senate Bill 53.
Excellent. Thank you very much. All right, next we'll move on to Ms. Lampell. There you are. Welcome.
Good afternoon, and thank you very much, Senator Smith and the committee, for allowing me to testify. My name is Anita Lampell. I live in District 16, and I'm speaking in favor of SB 53. My background and training is in child and adolescent mental health. I have a PhD from Stanford. I ran a child and adolescent mental health program for a large county in which I also worked closely with juvenile justice, providing legislative insight, assisting with expert testimony, and interviewing many, many children. I can tell you unequivocally, as have many other panelists, that children and youth don't think in the same way as adults. They're a protected group in society for this very reason, that they do not have the reasoning skills or the behavioral controls that come with adulthood. Children are, as many have already said, far more likely to give false confessions, not understand the consequences of their statements, and conform to the pressures of the moment. Their cognitive abilities are worse if they live in poverty, are exposed to violence, or have learning disabilities, or are the member of a targeted group, such as being Black. Now, children and youth deserve to have and should have, and in fact must have, legal counsel before being questioned, and their parents should be notified that they are being questioned. Now, this is a standard in most civilized countries. It's a standard in multiple states and is supported by major advocacy groups for children, like the American Psychological Association and the American Psychiatric Association. Maryland, this liberal state, has been identified as one of the 3 worst states in the country for juvenile justice reform. We have to fix this. Thank you very much for listening.
Appreciate it. Thank you very much. Next, we'll go on to Ms. Drennen. Cara, how are you?
I'm well, thank you. It's Drison, but that you had a 50-50 shot.
My apologies. Welcome.
No worries. Thank you, Mr. Chair and members of the committee, for the chance to speak today. My name is Cara Drennen. I'm a law professor at Catholic University and an expert on juvenile sentencing and justice matters. I'll be speaking today on both bills, so I'll just be brief. First, 2 points I want to make in support of this bill. The first is that this bill is consistent with the science of adolescent brain development. Now, I know this committee has heard quite a bit about that science, and so I won't repeat all of that, but just to remind folks, the frontal lobe is still developing until about the age of 25, and that is the portion of the brain that governs things like judgment, planning, problem solving, and risk assessment. One of the key attributes of an immature brain is valuing short-term gain over long-term consequences. And as you can imagine, in the interrogation context, this often translates into a false confession so as to go home, notwithstanding catastrophic consequences from such false confessions. So given the inherent and unfair disadvantage children face in the criminal process, especially the interrogation process, I view SB 53 as one step toward recognizing and remedying that unfairness. That's point one. Point two, I'd just like to mention is that this bill is also consistent with Supreme Court precedent, about which I have written extensively. In particular, in a series of cases known as the Miller Trilogy, the court leveraged that adolescent brain science I just mentioned to hold that children are different for constitutional purposes. We've also heard reference to JDB, a decision in which the court held that a child's age, the fact of being a child, is relevant to the Miranda custody analysis. I want to just point out that the court in JDB itself said, quote, by its very nature, custodial police interrogation entails inherently compelling pressures that, unquote, that new quote, could induce a frighteningly high percentage of people to confess to crimes they never committed, close quote. And the court went on to recognize that's only an enhanced risk when the suspect being interrogated is a minor. So in sum, I would just say that SB 53 is consistent with both the science of adolescent development and longstanding Supreme Court precedent in this space. And for these reasons, I support the bill. Thank you for your time.
Excellent. Thank you very much, Professor. All right, we'll now move on to Miss Lipscomb. I think I saw you here. Oh, there you are. 1 second. Call back. Too many screens. All right.
Thank you so much, Mr. Chair. I appreciate your the committee permitting me to speak today. I appreciate being here. My name is Lauren Lipscomb. I am a Deputy State's Attorney for Criminal Intelligence in Baltimore City. I founded the Conviction Integrity Program within the Conviction Integrity Unit here in Baltimore City. And I'm a career prosecutor of almost 20 years, having tried dozens of jury trials, hundreds of bench trials, ultimately directing the investigations into factual innocence claims, resulting in the release of 12 men wrongfully convicted. These investigations are a postmortem of cases which reveal contributing factors and patterns. We have a shared goal of promoting public safety by building solid cases against violent offenders and reaching just outcomes. Wrongful imprisonment or convictions derail these goals at all stages of criminal justice contact. It is our opinion that this bill adds necessary safeguards, contemplating the known science and common sense, while not detracting from our shared goals of bolstering public safety by building solid cases and reaching just outcomes. 8 of the 12 wrongful conviction cases that I investigated involved heavy or exclusive reliance on statements from juveniles. None had counsel, few had parents. The scientific data has been presented over several years of sessions and over several minutes here, even this afternoon. Miller Montgomery, the Supreme Court of the United States, noted juveniles lack maturity, are more vulnerable to outside pressures. Their character is not as well formed as adults. If we know these things to be true and should be considering these things in sentencing, and are reasons why juveniles can't buy a car, these considerations should inform all stages of contact between juveniles and the criminal justice system, including interrogations. Additionally, this bill affords an exigency escape valve for police. If police need to act urgently, this bill does not preclude them from being able to do so. Again, building solid cases promotes public safety. Thank you so much.
Excellent. Thank you very much. Always good to see you.
You as well. Thank you.
Please. All right. Next, we'll move on to Miss Berry. I saw you. There you are. Welcome. Good to see you.
Thank you. Thank you. And can you hear me?
We can.
Okay, great. I have some sign up here that is suggesting otherwise. So I thank you for this opportunity to speak in support of SB 53. And thank you, Senator Carter, for your leadership in sponsoring it. I'm a visiting professor at American University's Washington College of Law, and I direct its reentry clinic. But today I'm here to speak as a member and on behalf of the Montgomery County Women's Democratic Club, one of the largest and most active Democratic clubs in the state. Passage of this bill is one of the organization's priorities for this legislative session. I'll also be testifying in support of SB 165, and we have submitted written testimony on both. In March of last year, many of us read with alarm the report of 2 police officers handcuffing and threatening a 5-year-old boy who had the temerity to leave his East Silver Spring Elementary School. The boy begins to cry and cough as one of the officers forcibly put him in the back of their police cruiser. "I don't want to go," he cries. The body cams have the officers saying, among other disturbing things, "A crate him if he's going to act like a little beast." I raise this because while I sincerely hope that the officers were not indicative, it reflects a sense, supported by at least one Maryland study, that police do not make much needed distinctions in how they treat children. While one should question the effect of tactics such as bait and switch, lies, isolation, intimidation, and gaining reliable results from adults, as others have testified, they are as wrong as they are ineffective when applied to children. According to the National Registry of Exonerations, 38% of exonerations for crimes allegedly committed by youth involve false confessions, triple the estimated rate of false confessions generally. Fixated on their desire to return home, children are as willing to say whatever they can to free themselves from an interrogation room. Having a child suspect in hand often spirals to the beast assumption, one who is patently guilty and deserving of no rights, no attorney, no parent, no attempt at a meaningful Miranda warning, no right to honest treatment. We need this law to pass because we must care about a fair system. There's nothing fair about isolating, lying to, intimidating, and scaring children into confessions. Thank you.
Excellent. Thank you very much, Ms. Berry. All right, excellent. We'll now move on. So is James Dold here? I didn't see.
Right here, Mr. Chairman.
Oh, there you are.
Hi.
Well, good to see you. All right.
Good to see you as well. Thank you so much for allowing us to testify today. And I want to start off my remarks just by thanking Senator Carter for her leadership, as well as Delegate Bartlett for introducing this over on the House side as well. Just want to give a brief background about our organization. One of the things that makes us unique at Human Rights for Kids is that our board of directors is primarily made up of both Republican and Democratic state lawmakers from across the country. We have 6 Republicans and 5 Democrats from states as liberal as Vermont to as conservative as Arkansas and West Virginia. One of the things that brought all of us together was this recognition that we really needed to protect the human rights of kids who are in our criminal legal system. One of the recurring themes of most of our board members, just like Senator West actually, is that they've sponsored legislation in their home state ending the practice of sentencing children to die in prison. These protections are really human rights issues that are embedded within the UN Convention on the Rights of the Child, as well as the International Covenant on Civil and Political Rights, specifically the right to assistance of prompt legal counsel when a child is deprived of liberty is found in Article 37 and Article 40 of the CRC. Unfortunately, the United States of America is the only country in the world that has not ratified that specific provision, which has allowed vast human rights abuses to happen against children in the United States, and specifically right here in the state of Maryland. In 2020, we rated every state in DC on how well or how poorly it protected the human rights of kids in the legal system. And unfortunately, Maryland was in the bottom of that ranking. It was right down there with Alabama and Mississippi and a number of other states for not having basic human rights protections in place and likely being in violation of international human rights law, or certainly international human rights standards. Many of that is actually going to change because of Senator West's bill, but this bill is essential to making sure that Maryland stays on that trajectory to make sure that we are protecting the basic and fundamental human rights of children as they enter the legal system. Many of our conservative board members who have advocated for this very same bill in other states and would advocate for it here in Maryland oftentimes argue on behalf of victims in the system that this is essential to make sure that law enforcement investigations have integrity, that we don't rely on false or coercive testimony, and that we also make sure that we protect law enforcement from being accused of using false or deceptive tactics against children. And so from a law enforcement standpoint, it's also an effective tool from that standpoint. So we would just urge this committee's favorable support in making sure that we're protecting the basic human rights of children. That starts at the point of arrest. Thank you, Mr. Chairman.
Excellent. Thank you very much. All right, next we'll move on to Mr. Moroney. I saw you here earlier.
Chair Smith, can you hear me?
There you are. We can.
Okay, I don't know if you can see me. I don't seem to have the power to turn on my video here, but oh, hold on one second. I'm sorry. Okay, there we go. So yeah, name is Nick Moroney. I'm the director of the Juvenile Justice Monitoring Unit here in Maryland, which is basically the juvenile justice independent monitor for the system. And what we do is we perform unannounced visits to detention centers that hold kids and to placements that hold kids in the juvenile justice system. And we report publicly as a result of those unannounced visits. We report publicly, and those reports are on the Maryland Attorney General's website, because we are housed, even though we're independent, we're housed in the Maryland Attorney General's office. So the Juvenile Justice Monitoring Unit supports SB 53. Police, as we have found, are not required to call parents or guardians or an attorney before a child is interrogated, no matter how young the child is or how serious the charges are. And yet studies show that children don't understand or feel comfortable exercising their due process rights and end up giving them up 90% of the time, making false confessions, as we've heard, at rates exponentially higher than adults. So this bill, SB 53, will protect children and young people by making sure parents are informed and a public defender is being consulted when young people are taken into custody and before they are questioned or subjected to an interrogation or interview. Such situations, these kinds of interrogations, these kinds of interviews involve an unconscionable misbalance of power as young people face legal jeopardy alone. Children and young people have not yet developed a sufficient sense of self-confidence to defend their best interests in such a predicament, as well as the brain science that we've heard about as well. We also know that young people make impulsive decisions, and yet we currently leave them alone facing authority figures who can influence for better or for worse their entire future life and career trajectory. And so the bill should be supported because it offers a modicum of protection to children and young people in potentially precarious situations and at a time when they most need or are entitled to legal help. And as the independent monitor at the Independent Monitoring Office for the last 14 or 15 years, we do not want to see kids in the system who should not be in the system, who do not need to be in the system under any circumstances. And so for that, we urge you to respectfully urge you to and the committee to give the bill a favorable report. And thank you very much for your time.
Excellent. Thank you very much. All right, next we'll move on to Mr. Apple.
Thank you very much, Mr. Chair, Mr. Vice Chair, distinguished committee members. I am Chris Apple. I live in Columbia, Maryland. I'm not a lawyer, just an average citizen, but I do know that a criminal record can have an incredible crippling influence on a person's life. It can make it harder to get a job, find housing, or to qualify for public assistance. As we've heard today, studies have shown that juveniles have difficulty understanding the real gravity of their choices in an interrogation room. They're probably alarmed, possibly alone, and as today's testimony shows, children often feel pressured into waiving their Miranda rights to appear cooperative. This would be problematic even if all child suspects were guilty, but as we've heard, an alarming number of innocent child suspects waive their rights as well and go on to issue false confessions. One study I found showed that up to 44% of juvenile exonerees issued a false confession when they were arrested. So that's almost half of child suspects who turned out to be innocent and yet confessed to a crime that they did not even commit. This certainly is a compassionate bill, but I think it's also a practical bill. I'm not a lawyer, but I understand that improper Miranda waivers can result in evidence being thrown out or even in a mistrial. This bill would let an attorney see the waiver in action from the very start. If the child's rights were not properly observed, the attorney can immediately bring it to the attention of the court, which might save all parties a lot of trial preparation and emotional anguish. We can't truly say a child can exercise a right if they don't understand that right. I think this is a good bill. I think it recognizes that juvenile suspects are in fact vulnerable in that interrogation room and need extra assistance to understand their rights. Both of the studies I've mentioned today are linked in my written testimony if any of the distinguished committee members would like to review them. And I respectfully urge the committee to issue a favorable report on SB 53. Thank you very much.
Excellent. Thank you very much, Mr. Apple. All right, next we'll go to, is Ms. Beverly here? There you are. Welcome.
Okay, thank you so much. Okay, can you hear me?
We can.
Okay, great. Good afternoon, Chairman Smith and members of the committee. My name is Cassandra Beverly. I'm a resident of Harford County, and I live in Senate District 34, and I'm also a member of Bridge, Maryland. I'm an attorney with a general practice that includes criminal defense. I've been in practice for over 30 years, have practiced in Baltimore City, Baltimore County, and Harford County, and a little bit in Cecil. I'm testifying today on behalf of Senate Bill 53 to urge you to vote favorably on this bill that will protect the most vulnerable amongst us, our children. I find at this hour that most of the testimony that I was prepared to give has already been commented on, and I'm very, very happy to see how well supported this bill is. Current law recognizes that adults need protection when they are subjected to custodial questioning. We must surely then understand that our children need and deserve the same level of protection. And I cannot tell you the number of times that I've seen older teens who are technically adults who have struggled after being subjected to custodial questioning. Most parents would be shocked to learn that their minor children can be interrogated and placed in custody with no notice to them or to a guardian, and more importantly, no access to an attorney. My work as a defense counsel has given me a deep appreciation for how very intimidating custodial questioning is for adults, let alone for a child. These highly stressful interrogations can produce false confessions and admissions in adults. Children are taught to respect authority and are unaware that police officers can lie to them during an interrogation in order to gain an admission or confession. They want to please people in authority and may tell them what they believe that the officer wants to hear. As a society, we owe the highest duty of protection to our most vulnerable. This legislation provides you with an opportunity to provide much needed protection for our children. I strongly urge you to vote favorably on this bill, as it will be a major step forward in the effort to end the school to prison pipeline. And I thank you for your time.
Thank you for your time. All right, excellent. We will now go on. Justin, I got you. Here you go. You're up next. And then Ms. Stouse, you're on deck.
Thank you. Good afternoon, Chair and members of the committee. My name is Justin Nally, Policy Analyst at the ACLU of Maryland. I come to you today in support of Senate Bill 53, the Child Interrogation Protection Act. The bill as presented passed the House in 2001 and is innocuous legislation that protects the due process rights of children. In this country, we protect children from themselves under 18 all the time because we know they don't have the capacity to make lifelong altering decisions regardless of their individual intellectual development. We are responsible for ensuring that children are not manipulated or abused by adults and that their unknowing nature can be taken advantage of. This legislation simply ensures that a child during a custodial interrogation has the opportunity to speak with an attorney prior to any questioning so they can understand their rights. We protect children in all different areas of their life. This legislation is simply an extension of that practice. So we know that this bill also allows law enforcement to have some protection when they are questioning children, because it protects those procedures and protects their processes from scrutiny because we have a law in the books to take place. Lastly, we also know that Black boys and girls are the most impacted by the legal justice system and require the most protection of their civil rights and civil liberties. So I ask, as you consider this important legislation, that you look at it through the eyes of a child, but also look through it through the eyes of a parent. And you know from this vantage point that you know that if your child was in this situation, being interrogated by police, one, you want to be notified, and you want an attorney to be there to understand and explain to the child what is happening. So I urge the committee to take this bill up for a vote and a favorable report to continue to protect children in Maryland. Thank you.
Excellent. Thank you very much, Mr. Nally. Now let's move over to Ms. Stouse. You're up.
Good afternoon, Chair Smith and committee members. Thanks for hearing from Marylanders today on Senate Bill 53. My name is Katie Stouse. I'm a Montgomery County resident and parent of a preteen and teen. I'm representing Tacoma Park Mobilization, a grassroots group with over 2,500 residents in our network, and we urge support of Senate Bill 53 to protect children who are facing interrogation from needless traumatic interactions with police and from needless entanglement in Maryland's criminal system. Others today have already spoken about the racially disparate impact of youth interrogation and how difficult it can be for adults, much less children, to navigate police interactions without a lawyer. Our written testimony covers these points and highlights the case of my friend Tiffany Kelly's son, a Black child with special needs who was interrogated at his school in Chevy Chase when he was 10 years old for having play money on the bus. If this bill had already been law, sanity would surely have prevailed and he would have been left alone. Police access to him was too easy, and this experience harmed him, as you can well imagine. In addition to racially disparate impact and trauma, youth interrogations without lawyers simply don't work as intended, and they lead to tragic miscarriages of justice. I can say from experience as a parent and I'm sure many of you can relate, that kids often say what they feel they need to say to end a scary interaction, all the more so for children who have already experienced trauma. And so in the presence of police, they make either misstatements or false statements because of fear or confusion. And the data backs that up, as we've heard. The National Registry of Exonerations records that 36% of exonerated children falsely confessed compared to 10% of adults. And in another study, nearly 35% of youth wrongful convictions involved unreliable statements by a youth witness. In light of all this, we urge a favorable report on Senate Bill 53 so Maryland can get on par with other US states and align ourselves with international human rights norms. Thank you.
All right, excellent. So that'll conclude the testimony for the proponents of the bill. We'll now switch over to the opposition panel of the opponents, and we'll start off with Mr. Culver. There you are.
Good afternoon, Mr. Chairman. Mr. Chairman, members of the committee, my name is Alan Culver and I'm the state's attorney for Carroll County. I'm here today to testify in opposition to Senate Bill 53, the Juvenile Interrogation Protection Act. The bill would effectively eliminate the ability to question a juvenile in custody for even the most violent crimes such as rape and murder. To use a statement against a juvenile at trial, the state must already prove that the state was made voluntarily beyond a reasonable doubt, requiring that a juvenile consult with an attorney and requiring law enforcement to make efforts to contact the juvenile's parents, guardian, or custodian prior to questioning where there is a reasonable basis that they'd received notice are unnecessary logistical hurdles that change the burden from beyond a reasonable doubt to almost impossibility. The questioning of a possible suspect can begin as a consensual encounter and develop into custodial interrogation. As a result, many law enforcement officers will review Miranda with suspects even when questioning has not risen to a custodial interrogation. Under this bill, law enforcement will be deterred from taking a conservative approach on custodial interrogation with juveniles because custodial interrogation will effectively end the ability to question a juvenile. If the concern that produced this bill is that juvenile rights are being violated during custodial interrogations, then simply require that all juvenile custodial interrogations be audio and video recorded. It is in the best interest of all parties involved that they be audio and video recorded. Such an interrogation then can be reviewed by the court and barred from being used against a juvenile if the court has concerns about interrogation. Statements given by suspects are not only used at trial, but are often used to further investigations and lead to the recovery of evidence and the identification of other suspects. Statements given by juveniles can also work in a juvenile's benefit. I handled a home invasion case where a juvenile and 4 adult co-defendants had a firearm, broke into a home, and took items from a home. The juvenile suspect provided a statement that limited the juvenile's culpability and in the case, which significantly benefited the juvenile in the disposition of the case. I urge an unfavorable report for Senate Bill 53, as this law effectively ends the ability of law enforcement to question juveniles in custody. Thank you.
Excellent. Thank you very much. We'll now move on to Mr. Massey.
Can you hear me?
We can, yes.
Okay. Thank you, Mr. Chairman and committee for letting me speak. My name is Ryan Massey. I'm a Baltimore County police officer. I was a homicide investigator for 14 years. As police, if we want to interrogate anyone, we have to advise them of their Miranda rights. That includes juveniles. Not only do we have to advise them of those rights, but we have to ensure that they understand those rights. A blanket policy would prohibit us and is not in the best interest of the public. There are many things that a police officer has to take into account when he's doing an interrogation. I would proffer that the Maryland General Assembly has furthered those interests by requiring and mandating police departments to wear body-worn cameras, and specific interrogations have to be audio and video recorded. In 2007, Carl Lackle was murdered in Baltimore County. Mr. Lackle was cooperating with the Baltimore Police Department as he was a witness to a murder. The juvenile that killed him asked him if he knew the way to heaven right before he shot him. Lowen Powell killed his mother and laid in wait for his father to return home and brutally attacked his father. Nicholas Browning killed his parents and his 2 brothers. Robert Gladden, a school student at Perry Hall High School, went to school with a loaded weapon and shot a classmate. And Officer Amy Caprio was investigating a burglary when she was fatally killed in the line of duty. All of these juveniles were given their Miranda rights. All of these interrogations were audio and video recorded. Just as recently as in 2021, there was a school shooting in Michigan, and the juveniles' parents were charged as accomplices. The toughest part of my job is to tell a family that their loved one has been murdered. As written, this legislation would prevent me from using a tool to get that family answers in their time of grief. I would just oppose the legislation as it is written. Thank you.
Excellent. All right. Thank you very much. We will now go on to Mr. Spencer.
Good afternoon, Mr. Chairman and Member Senate. I adjust my camera here. There I am. So I'm here on behalf of, my name is Jerome Spencer. I'm the General Counsel of the Charles County Sheriff's Office. I'm here on behalf of the Maryland Chiefs and Sheriff Associations and on behalf of Sheriff Troy Berry, and we're respectfully asking for an unfavorable vote on Senate Bill 35. Let me start with what we agree on. And believe it or not, there are some things we agree with. We 100% agree that the Court of Appeals should be encouraged to pass more language appropriate Miranda version. Absolutely agree with that. That would be very helpful and helpful for the Court of Appeals to do that, because what the Court of Appeals has told police officers over and over again is that when they deviate from the current Miranda litany, problems can ensue. And for a large part, the first part of the bill involving parental notification, no real objection from Chiefs and Sheriff Associations about that either. We agree it's important. Parents should generally know. Now, there's going to be the unusual case where perhaps the juvenile in custody murders parents or parents are abusive. Might be situations where that would be a problem, but in general, not an area of much concern here. Really, where the concern comes down to is the practicality of this bill. And you heard State's Attorney mention just that. State's Attorney Culver talked about just that. So the way this bill would work, anytime a juvenile is in custody, before any custodial interrogation can even begin, everything must stop. Doesn't matter on the side of the road, at a home, in a station, everything must stop until they find that attorney who's on call to go over their rights with the juvenile, the same rights the detective or the officer has in his or her car to read to the child. And for what? The concern, we've heard a lot of concerns about from the proponents of the bill, and we agree with those concerns. We all agree an involuntary statement is a bad thing. We all agree a false confession is a bad thing. I hope we all agree that a voluntary statement is a good thing. State Attorney Culver told you about at least one example where a statement actually helped the client. This bill doesn't really address that. This bill simply says we must stop and can do nothing until we have that consult with an attorney. May or may not answer the phone right away. They're supposed to, may not, can't even get the refusal or the implication right. And it's simply an impractical, unworkable bill for those some of the reasons why we ask for an unfavorable report.
Excellent. Thank you very much. All right. Next and finally, we have Mr. Potashnik. I saw him here earlier. There you are. Welcome.
Good afternoon, Mr. Chair. Seems like I'm always last on these things. That's okay. Gavin Potashnik, Deputy State's Attorney for Harford County, also representing the MSAA. I thank Senator Carter for bringing this important issue on Senate Bill 53. It's important for us to have these conversations. However, we are in opposition to this bill. I'm echoing something that Mr. Spencer had indicated, that in practice, I'm not exactly clear how a defense attorney is going to stop themselves from telling every single child, not necessarily what their rights are, but that just don't talk to police. Any defense attorney worth their salt is not going to just review the statement of Miranda rights. You're going to say, don't talk, just don't talk at all. And that creates a conflict for future representation. I would also add that in many instances, you have multiple suspects. Does that mean that the officer has to get multiple attorneys for multiple suspects? Does that mean that they're going to resolve conflicts with respect to that? I don't see that anywhere in the bill. Again, I completely support age-appropriate Miranda. I completely support having a parent notified. And I agree with Mr. Spencer that involuntary confessions and that false confessions are terrible. But voluntary confessions or voluntary statements do in fact lead to arrest of the right individual. And a specific example is we had a youth who'd been shot. He is in the hospital. The police go to speak with him and his attorney says, don't talk, period. At that point, then they don't know who shot him. They'll never find out who shot him. They have no other evidence, no other suspects, and somebody goes free on that crime. That just isn't right. And that's just one example of many times when voluntary statements made by youth do result in the right thing happening. This bill would essentially ban completely all statements from youth. And I don't think that that's something that we should engage in this state. Therefore, we would be asking for an unfavorable result. Thank you.
Thank you very much, Mr. Potashnik. I promise you it was not intentional, but the first will be last and last will be first. You'll be first in the opposition panel as I see your sign up for the next one. Unfortunate thing is that there are only 2 in opposition, so at least you bumped up one on the next bill. But all right, with that, that'll conclude the hearing for Senate Bill 53, unless I'm missing anyone. Seeing that, we are now going to move on to Senate Bill 165 with Senator Carter. Senator Carter, you're up.
Thanks, Chairman Smith, and thanks, committee, as always, for bearing with us in these long hearings. You've heard so much testimony earlier in the briefing about the efficacy of stopping the automatic charging of children as adults. I want to just stress to this committee that this is not even anything new or something that's exotic. It's already being done in a myriad of states deemed more conservative than Maryland. And all the way back to 2012, we had the data that is very similar to the data we have today that we've heard about that the Juvenile Justice Reform Council had looked at, that spoke to the fact that the overwhelming majority of children, over 80% of children that are automatically charged as adults, have their cases adjudicated outside of the adult court. They're not found guilty in adult court or they're waived back to juvenile court. And so I want to just point out to this committee something that has really troubled me greatly, which is the fact that we are hypocritical in Maryland about how we treat children and which ones we decide deserve to be protected and which ones don't. We don't allow children to contract. We restrict children's rights to work. We don't allow children to smoke or drink or vote, yet we're even considering stopping children from marrying because we think that people under a certain age are not capable of appreciating the consequences and full of their actions. Yet only in this criminal justice system do we say that children can automatically be started in the adult court. The hypocrisy of that is that we are leaving the burden on children to prove that they are children, rather than where it should be on the state to prove that this is an exception and that under these circumstances, we can meet a very, very low burden to say that these children should be tried in adult court. And so this has nothing to do with where the case is finished. This is all about where they start. Because you've heard so much testimony about brain science, about the fact that children's brains are not fully developed until their early 20s, some say 25. Because you've heard about their diminished capacity in terms of being able to control their impulses. You've heard about their immaturity. As lawmakers, it's our duty to maintain a fair legal system. The current practice of charging children automatically as adults is an unfair practice. Maryland children enter the court system, adult court system, at a rate higher than every other state except Alabama. In 2020, Maryland sent more children to adult courts than Arizona, California, Massachusetts, and Pennsylvania combined. Notably, 80% of these children were Black children, while this demographic represents only 30% of the state's population. Senate Bill 165 would address this injustice. Currently, children as young as the age of 14 are automatically charged as adults for crimes that, if committed by adults, are punishable by life imprisonment. For children 16 and over, this list of crimes that result in automatically filing in adult court is even longer. It extends to 33 statutory offenses. I would just remind us that we are talking about allegations that still must be proven. And so it is our belief that those allegations, that the determination on those allegations as to where a case should wind up should be better left to the discretion of a court rather than police officers or law enforcement. While the bill would possibly reduce the number of children referred to adult court for crimes committed before full development of their brains, it would not completely halt the practice. Juvenile court judges, at their discretion, will still be able to refer serious offenses to adult court, but that will be based on full consideration of all the circumstances and all the factors being considered. Discretionary power is crucial to Maryland's children. Children entering the criminal justice system, no matter the severity of their crime, deserve consideration of their age. The end of automatic direct filing means that juvenile court has more opportunity to intervene and rehabilitate children. These evidence-based, proven interventions have positive long-term outcomes. They disrupt cycles of generational violence and strengthen our communities. No child in Maryland should be sent to adult court without full consideration of their developmental status and an attempted intervention through the juvenile system. This bill would put an end to that, providing a higher standard of judicial protection for our children and our communities. And so for these reasons, I would urge a favorable report. Thank you for your time.
Well, thank you very much, Senator Carter. All right, we'll go on to your panel. We have Ms. Williams. Crystal Williams is first. Hold on, there you go. Welcome.
Thank you, Chairman, and good afternoon, members of the committee. My name is Crystal Williams. I'm the Director of the Government Relations Division for the Office of the Public Defender. I'm here today in support of this bill, one that is top priority for our agency, given the broad impact it will have on those we represent. We must start by asking, why are children engaged in committing terrible offenses? Treating them as adults, however, does nothing to answer that question, and it does nothing to protect public safety and prevent it from happening. As an attorney in Baltimore City's Youthful Defendant Unit, I represented countless kids who committed serious offenses ranging from murder to selling drugs. I also represented kids who were star students but were swept into the system for getting into a fight at a basketball game, a mistake that became a first-degree felony assault charge subject to 25 years of incarceration. Automatic charging sweeps all children into a system that is neither designed nor equipped to address their most fundamental and basic needs as a child. It does nothing to account for their background or rehabilitate them as the malleable young children they are, with the malleable young minds that they have. We seem to all agree that children must be treated as children even at 16 and 17 years of age if they are viewed as a victim of abuse. But we have yet to recognize legally that sometimes that same child, often as a result of being a victim, may commit a criminal offense. The actions committed by a child or against a child does not change the fact that a child is still a child. We must stop using criminal offenses as an excuse to criminalize children and their trauma. We must ask what is going on in their minds, what is causing them to act out. As an attorney, I spent hours with children getting to know them and hear them and see them. Sometimes they would get angry and act out, but when given the room to calm down, breathe, and understand that I cared about them as a person, not simply as a defendant without a name or a story, when they felt seen and heard, they would open up, shed tears, and explain to me the pain and fear they were experiencing. Children who commit horrible offenses oftentimes have had horrible and unspeakable things happen to them. I've represented clients who have been sexually abused, physically beaten, and left to fend for themselves in abandoned houses with no food, electricity, or supervision. Those who have been beaten for reporting their abuse, and children who have witnessed their parents suffer with addiction and overdoses, and sometimes witnessing their death. I had once had a client who woke up from a parent who had died next to them in bed. These children are suffering, and that suffering can manifest into destruction when they do not get the appropriate treatment, attention, and care to address their trauma. Too many times when asking my client why they did what they did, they tell me, no one cares about me, so why should I care about them? That is a heartbreaking answer that shows we have failed these children. We encourage laws like this not to minimize the impact of crime on victims, but to prevent all persons from being victimized and to not negate the trauma of all victims. All kids need to know that we care about them and their future so that they not only care about themselves and their futures, but also of their fellow neighbors. Prosecuting children as adults is not, I repeat, is not a deterrent to crime, but the exact opposite. It results in more crime and more violent crime. If you are not persuaded that we should stop criminalizing the trauma of neglected, abused, and lost children, or you are not convinced that it is costly and inefficient, then you should at a minimum be persuaded and convinced that prosecuting children as adults simply does not work as a public safety measure, but in fact shows that it makes the public less safe. We know that rehabilitation works, and rehabilitating children is a positive public safety measure that we should all support. Thank you.
Excellent. Thank you very much, Ms. Williams. All right, next we'll go to Dr. Abrams. There you are. Oh, one more time.
Okay, thank you, Chairman Smith, and good afternoon. My name is Dr. Abrams, Laura Abrams. I'm a professor and chair of the Department of Social Welfare at UCLA in the School of Public Affairs. I've been studying youth justice policies, treatment and intervention practices, youth and families, and system actors for over 25 years. I testify today in strong support of SB 165. In the 2 minutes I have, I want to share a few key lessons from numerous studies I have conducted, along with those of my academic colleagues. The first is that children have individual needs and backgrounds that can only be fully vetted in the juvenile court before deciding on a charging decision. Much of children's rule-breaking behavior is due, as we've heard, to the hallmarks of youth or result from immense traumas, which the last speaker mentioned. We need to assess each child individually before a life-altering decision is made to send a child to an adult court and possibly to terminate their life in the free world as they've known it. Research also finds, second point, that youth cannot be presumed competent to stand trial as adults. Again, I emphasize presumed competent. According to the United Nations, the minimum age that a child should even be prosecuted, even in a youth court, is age 14. A law such as in Maryland that allows a 14-year-old to be automatically filed contradicts international children's rights standards. Third, automatic charging is racially biased. Decades of rigorous experimental science has shown us that Black youth are seen by system actors as more adult-like than their non-Black counterparts. If automatic charging is removed from the equation, these harmful racial disparities can be at least partially addressed. Fourth, in California, where I live, the option to file minors directly into adult court was eliminated in 2016 by Proposition 57 with no consequence to public safety. This law has resulted in dramatic declines in the transfer of youth to adult court with no known effect on public safety. In fact, most of the voters feel confident that they made the right decision. We need to end the costly and unnecessary policies that do not align with science and research. Maryland can be part of this change. I strongly support SB 165, which aligns with science and evidence-based public policy. Thank you.
Excellent. Thank you, Dr. Abrams. All right, next we have Secretary King, and then Mr. Rovner, you're on deck.
Thank you, Mr. Chairman, and thank you again to the committee. I'm grateful to Senator Carter for sponsoring this bill and the opportunity to testify on it, because for me, this is deeply personal. I only was able to become a teacher and a principal and Secretary of Education for President Obama because of the second chances I got as a kid. My story, like many of the young people who are automatically charged in adult court, began with trauma. Both my parents passed away when I was a kid. My mom when I was 8, my dad when I was 12. In the period when it was just my dad and me, my dad was struggling with Alzheimer's. Home was incredibly difficult. And by the time I got to high school after my dad passed and I moved around different family members and different schools, I struggled like many kids who've experienced trauma and actually got kicked out of high school. And it would have been easy for folks to give up on me, to say, here's a Black Puerto Rican male, family in crisis, no respect for authority. But I was blessed that there were teachers and a counselor who were willing to give me a second chance. That's the only reason I'm alive today. If I had been funneled into the criminal justice system that we have today in Maryland, I likely would be dead or in prison. This issue is about justice. As Senator Kelly often reminds us, no one is born bad. We've got to have a system that realizes that kids in trouble are still just kids, kids who've experienced trauma, kids who've experienced adverse childhood experiences, kids who institutions have systematically failed. This isn't to negate the need for accountability, but it is to say that we need real commitment to rehabilitation, real justice, education, mental health services, mentoring. We can do better. We have to do better. Our current approach ignores the evidence, ignores the science, and results in our having the highest rate of incarceration for young Black men in the country. It doesn't have to be this way. We owe it to ourselves, to our kids, and our communities to do better. For these reasons, I urge a favorable report on Senate Bill 165.
Thank you, Mr. Secretary. All right, next we'll go on to Mr. Robner. Sorry. All right, you there? Let me get you. One more time. Here we go. There you go.
Great. Thank you so much, Mr. Chairman and Senator Carter for sponsoring this bill, and really all the members of the committee. My name is Josh Rovner. I'm a resident of District 18 and Senior Advocacy Associate at the Sentencing Project. This legislature created the Juvenile Justice Reform Council to study the flaws in Maryland's youth justice system. After months of expert testimony, the JJRC endorsed ending automatically charging youth as if they're adults based on the offense. The resultant bill is SB 165, and we endorse it along with the interrogation reforms discussed earlier. Maryland's current transfer process is rife with flaws. Compared to other states, having a list of 33 specific charges is incredibly unusual and contradicts the advice of experts, such as a panel of the National Research Council who reject the way that Maryland does business. Indeed, decades of research, including a compendium from the Centers for Disease Control and Prevention, have shown that youth charged in the adult system are more likely to reoffend than their similarly situated peers in the juvenile system. And even worse, that their next arrest will probably be for a more serious crime. In short, this bill is good for public safety. With such a long list of charges, it's not surprising that, as you've heard, Maryland, per capita, automatically transfers more of its children into adult courts than any state except one, Alabama. Overwhelmingly, nearly exclusively, they are youth of color. The status quo sends hundreds of teenagers into adult courts to wait for a process that will dismiss the charge entirely or waive the children and adolescents back into juvenile court more than 85% of the time. It's an astonishingly inefficient system. This bill would start all their charges in juvenile court. That's already the law in 9 other states, a list that includes Texas, Tennessee, Kansas, Kentucky. This bill, like theirs, still allows children and teenagers to be waived upwards into adult courts. It simply requires a juvenile review hearing before doing so, and that's a matter of fairness. We urge this committee to vote on this bill as written as soon as possible. Thank you so much.
Excellent. Thank you very much. All right, Professor Drennen, you're up next.
Thank you once again for the opportunity and time. I'll be brief. Much of what we have discussed in the last 2 sessions covers my remarks. I just want to use my time to offer my support for SB 165, and in doing so, to offer some historical context. As I discussed in my book entitled The War on Kids, How American Juvenile Justice Lost Its Way, the juvenile court model was actually invented in Illinois in 1899 to recognize the fact that kids are fundamentally different from adults and that rehabilitation is typically the appropriate response even when youth are accused of crime. Thereafter, every state in the Union and developed nations around the world adopted the juvenile model just as a common sense measure. So it was not until the late 20th century in the United States that we began to abandon that model of treating children in juvenile court as a default measure. And we did so only amid rising crime rates, the war on drugs, I should say, and widespread panic about the now debunked juvenile super predator theory. So by the 1970s, as I said, automatic transfer provisions like we have in Maryland today became commonplace. Time has proven, the decades and since then have proven that these are harmful to youth and to society at large, and it is time to eliminate them. I would just close by mentioning, reiterating, I should say, what the Supreme Court has said about youth, which is that youth is more than a chronological fact. It is a stage of incredible vulnerability and capacity for change. And the last thing I would say is that in supporting this measure, I also note that this measure is actually quite modest in its attempts at reform, right? And this is a bill that is strictly about the origin of a juvenile's case and not about the ultimate venue for that child's case or even a possible sentence applicable. So again, I thank the committee for the time and the opportunity to speak in support of this bill.
Thank you very much, Professor. All right, we'll now go on to Dr. Tillman.
All right, thank you, Mr. Chair and committee. Bridge Maryland is a nonprofit faith-based organization that uses intentional relationship building, organizing, and intensive leadership development to strengthen congregations and faith leaders to demonstrate and advance justice in the world. One of our primary functions is raising the consciousness of Maryland on the great work you all have done and as your partners will do in the future. That is why Bridge Maryland supports Senate Bill 165. This bill addresses one simple fact: children and youth are not adults, and we should have the empathy to know and treat them differently. Maryland sends more young people per capita to adult courts based on offenses than any other state except Alabama. Is that the message we want our children to hear about the people who are supposed to care and protect them? Why does Maryland rank worst in the country for protecting the rights of young people in the legal system? A major reason that Maryland law requires some children to be automatically prosecuted in adult court for the 33 offenses, putting us out of the order with the states and international human rights law. I must believe we're better than this. I can believe we're better than this. I'll simply close with you having the rest of my written testimony with this. We can and must treat our children better. Maryland should join the 26 other states who have passed laws to treat kids like kids and end automatic charging. Bridge Maryland, a member of the Maryland Youth Justice Coalition, is continuing to asking for your favor on report SB 165. Thank you for my time.
Excellent. Thank you very much. All right, next we'll move on to Ms. Chaudhary.
Thank you so much, Chair Smith, members of the JPR Committee. On behalf of CARE, I thank you for this opportunity to strongly testify in support of Senate Bill 165. I don't want to repeat a lot of what was already said here today. Obviously, the fact that our state currently ranks amongst one of the harshest in the country when it comes to prosecuting crimes committed by children and teens under the age of 18 is something that should worry all of us. The way that Maryland law currently mandates children as young as 14 be automatically prosecuted in adult court for nearly 3 dozen different offenses is something that it's not acceptable. We're one of fewer than 10 states that send hundreds of children and teens to adult court each year, and we can and we must do better. Our children deserve this. They deserve our advocacy and our support on this. Children and teens who are charged as adults are more likely to receive longer sentences than youth who are charged with similar crimes in juvenile court, and research shows this. This disproportionately impacts Black and Brown communities. We know who are much more heavily policed, and the racial disparities that are fueled partly by children being viewed differently by law enforcement officers due to their background, their identity, their zip code. It continues to perpetuate harsher penalties. It erodes community trust and undermines the goal of rehabilitation. As mentioned, over the last 15 years, previously mentioned, 26 states have amended their laws. I can't see any reason why Maryland should not join that list. Key findings of a national poll conducted by Data for Progress indicated that a majority of voters across the political spectrum in a bipartisan way understand that young people have the capacity to change, and they deserve our support to make meaningful changes in their lives. They want the justice system. We want the justice system to rehabilitate young people rather than imprison them for life. And that's actually what's going to help improve public safety. Research on trauma-informed practices shows that trauma and toxic stress indelibly impedes cognitive development in children and teens. Youth who fall within this distinct developmental group have a unique needs and challenges, and there's only a critical window of opportunity where we can make meaningful interventions and have positive reinforcement. So we strongly support this bill. We believe that we can and we must collectively do better. Maryland should be at the lead. We should not be the ones who are at the bottom of the pack when it comes to juvenile justice reform. So we strongly support you to pass this bill. Thank you.
Thank you very much. All right, is Mr. Barr still with us? Mr. Barr.
Yes, yes, I'm here. Thank you very much, Chairman Smith, Vice Chair Walt Stryker, who is my senator in Kensington, Senator Carter, members of the committee. Thank you for the opportunity to address you. As you know, I've already submitted my written testimony. As you may or may not know, I am a retired judge from the Circuit Court for Montgomery County. I reached mandatory retirement last year, or about a little over a year ago. So I have seen juvenile court up close and personal. Of the 9 years that I was sitting as a circuit court judge, I spent about 3 of those years in the juvenile court rotation. So I spent a lot of time with juveniles. I also was a member of the Juvenile State Advisory Board for about 5 years as well, with Secretary Abbott and others. So, but also I was involved in criminal justice issues as a professor at American University Law School for many years, and also as a prosecutor in the Attorney General's office for 20 plus years, as well as a defense attorney. So I guess one thing I want to point out is, and there is some confusion from time to time about this, there exists in juvenile court waiver hearings. So whether a child is brought to justice in juvenile court or adult court, there is a full waiver investigation that's conducted, and this can and should be conducted in juvenile court, not adult court. We have mechanisms that are already there. There's no need for charging in adult court for all the reasons that have been stated. The juvenile judges are going to get exactly the same information, the same input from DJS, from the state's attorney, from the public defender, and from others. So this automatic charging in adult court really achieves nothing other than it's an inefficient system. It wastes a lot of time. It keeps a lot of people who end up in juvenile court anyway in adult court. So for all the reasons that have been presented, and for ones that I hope you will take into account, this automatic charging thwarts the purposes of juvenile justice. So I do urge the committee to issue a favorable report on Senate Bill 165. Thank you.
All right, excellent. Thank you very much. All right, now we'll have Ms. Watts. Is Ms. Watts here? There you are. There. All right. Welcome. I'm going to ask to unmute you here. Hold on one second. There you go.
Thank you, Senator Smith. I'm an attorney offering this testimony on behalf of my client, Andrew Zaragoza. He's currently at DOC's Patuxent Youth Program and so has no internet access. I was 16 years old when I was arrested for killing my mother. I loved my mother, but she was mentally ill and addicted to drugs. My dad died of an overdose when I was 15, and things got worse after that. When she was high, I often woke up with her climbing on top of me naked. About a month before, CPS came to my house, but they never talked to me alone, so I couldn't tell them about my mom. I tried to spend as much time as possible away from home, at friends' house and school and the gym. I was in 11th grade and in honors and AP classes. I wanted to move out of my parents' house and go to college. I had never been in trouble with the law before. On the night I killed my mother, she was high. She started molesting me and I told her I was calling CPS. She stabbed me in the chest, and at that point I fought back. I didn't mean to kill her. I just wanted her to stop, and I was afraid she was going to kill me. When I realized what I had done, I tried to kill myself. I texted goodbye to a few of my friends, one of whom called the police. I was taken to the hospital and had surgery. I woke up handcuffed to the bed by one arm with an IV in the other, and both of my ankles were in shackles. When I first got locked up, I felt lost. They put me in a padded isolation room for 14 days because I was suicidal. I was very mentally shut down. The depression was so bad, it was killing me. I just felt sadness, grief, and anger. Even after I was off isolation, I was still in a cell alone for 23 hours a day until I turned 18. Being on 23-and-1 was mental agony. It's more than just being bored. I spent 18 months on 23-and-1. I was never allowed to have a transfer hearing. It felt unfair that I never had a day in court to prove that I was a juvenile and that I could be rehabilitated. I think I can still have a bright future, but being charged as an adult has made it a lot harder. I'm blessed that I have support. I see other people here who don't. They aren't getting what they need. They're getting more lost. And being in here isn't helping anybody. It's just making things worse. And if any of you have any questions, I'm happy to answer them offline. Having been a practicing attorney for 22 years, I've handled hundreds of transfer cases, so please feel free to contact me. Thank you.
Excellent. Thank you very much. All right, next we'll go with Ms. Chakowski. Here you are.
Good afternoon, Chairman Smith and members of the committee. My name is Carol Chakowski, and I'm appearing today on behalf of the Montgomery County Commission on Juvenile Justice. This commission includes 22 citizen members like myself, and also representatives of other agencies and organizations concerned with juvenile justice. Thank you for the opportunity today to testify in support of Senate Bill 165, a bill that will end a practice that we see as harmful and ineffective. Science and research about the brains and behavior of adolescents tells us that lawmakers got it right a century ago when they established a separate system of justice for children with a focus on rehabilitation and not punishment. They recognized that children were different than adults and that it wasn't society's interest to treat them humanely. We see automatic charging as an indefensible departure from the principles of juvenile justice. We hope that the committee will recognize that the public interest in safety and in justice has not been well served by throwing hundreds of kids into the adult system every year, where they run the risk of never having access to the therapies, education services, rehabilitation that are critical to addressing their long-term needs and ensuring public safety. We think smart public policy argues for affording all young people who make mistakes, who commit crimes, the opportunity for change afforded by the juvenile justice system. With respect to transfer hearings, I want to mention that we think it's simply not right to burden children, 80% of whom are Black, with having the responsibility of having to convince a judge that to see them as children and to give them access to a system that was created for the benefit of all children. We strongly urge a favorable report on Senate Bill 165 as drafted. Thank you very much.
Thank you very much. All right, next we'll go to Mr. Kroom.
All right, Chair Smith and Senator Carter, thank you for sponsoring this. Members of the committee, again, not speaking officially for the courts, but for Marital Alliance for Justice Reform. I'd like to say, based on my years of experience as a juvenile court judge, I totally agree with retired Judge Gary Barr that to delete the reverse waiver where prosecutors make the decision as to a case starting in adult court would not have a substantial adverse impact on our court system. It would work very smoothly. You would get the same information, the waiver reports, psychological evaluations, but you would avoid some of the adverse consequences. You would avoid the adverse consequences of 80% of the folks who start there not having a conviction. And something which I haven't heard from other witnesses yet is that even when you're a case that was reversed waived back to juvenile court, you still have those adult charges on your record potentially forever. And that is a very negative consequence because the expungement system is not set up to resolve those adult charges. So by adopting SB 165, we would solve that problem, in effect, two birds with one stone prospectively. And it would also be better in the sense that the juvenile system is generally set up for rehabilitation. The adult prison system is not set up for rehabilitation. And for that reason, it's no surprise that the studies show that juveniles who stayed in the adult system have increased likelihood of reoffending. So SB 165 would reduce the likelihood of reoffending. It would reduce the collateral consequences. It would not be any inconvenience for the court. It would put the burden on the state where it should be. And it would also help the state of Maryland to save federal funds that we're in danger of losing, as well as becoming less racially inequitable, since it's very disproportionate the way that the current law is used. So for all these reasons, we strongly urge you to support SB 165.
Excellent. Thank you very much. All right, next we'll head to Mr. Frazier. Is Mr. Frazier here? There you are.
Yes, sorry, I am here. I was caught muted. Good afternoon, Mr. Chair, members of the committee. My name is Darrell Frazier. I serve as the Policy and Community Engagement Manager for the Mental Health Association of Maryland. Senate Bill 165 provides due process protection to Maryland children by requiring that all criminal cases involving a minor begin in juvenile court, not adult court. This bill would not prevent children from being tried in adult court. It just means that a judge will get to decide which kids get tried in adult court after a full hearing rather than law enforcement. According to the Sentencing Project, there is an overuse of automatic transfer. States have shrunk their use of automatic transfer down from 15,000 to under 10,000 per year over the past decade. The youth justice system has the skills, staff, and knowledge to assist young people. The charges placed on a young person do not drive dangerousness or risk to public safety. Starting kids in the adult system and then returning them back to the juvenile justice system exacerbates trauma and recidivism. Only 9 states currently send more than 200 kids to the adult court every single year. When we lock up young people, they are more likely to be exposed to extreme violence, fall prey to abuse, and suffer from illnesses. Even if young people manage to escape direct physical abuse in the juvenile or adult facilities, exposure and proximity to violence in and of itself causes trauma. Racial and ethnic minorities have less access to behavioral health services than our counterparts. They are less likely to receive needed care, and they are more likely to receive poor quality care that they are treated. Troublingly, although this results in desperate minority criminalization, incarcerated people of color are less likely to be identified as having a behavioral health disorder and are less likely to receive treatment. For these reasons, MHAMD supports Senate Bill 165 and urges a favorable report. Thank you.
Excellent. Thank you very much. All right, next we'll go to Ms. Goman. Melissa, I saw you over there. There you are.
Hi, thank you, Chairman Smith, Senator Carter, and members of the committee. My name is Melissa Goman, and I'm here representing the National Juvenile Justice Network in support of this bill. We are a membership network, and our members are juvenile justice advocacy groups all across the country, including in Maryland. As we've conveyed in our written testimony, charging youth as adults is a very serious, life-altering decision, and so it requires the serious consideration of a judge. And this does not mean that a minor cannot be tried in adult court, only that a judge will have to make that decision and that determination. Based on our research, the negative ramifications for the young person, as you've heard from many others today, and for public safety are multifold. One, youth held in adult facilities are at far greater risk than youth, even in juvenile detention facilities, physical and sexual abuse, mental health deterioration, and suicide. Two, adult prisons clearly were not designed for young people. They were designed for adults. And so they don't have the services that young people would need to be rehabilitated, including educational services, especially special education, as well as physical and mental health treatment. 3, an adult record leads to collateral consequences, including much greater difficulty getting jobs and furthering their education when they do return to society. So all of this leads to the direct negative impact on public safety. The research shows that youth tried as adults have a much higher recidivism rate than similarly situated youth that are kept in the juvenile system. And finally, automatically charging youth as adults exacerbates the already very significant racial inequities in Maryland's criminal justice system. So in Montgomery County alone, where I live, 95% of youth charged as adults in courts in fiscal year 2021 were either Black or Hispanic. The national tide is understandably turning away from this process of automatically charging youth in adult courts. And we've gone from approximately 15,000 children per year that are auto charged to 10,000 per year over the past decade.
Time.
Thank you. So we urge you to join this movement and vote in favor of SB 165. Thank you so much.
Excellent. Thank you very much. All right, we'll go to Ms. Silak. Sorry. Maya, welcome.
Thank you very much, Mr. Chairman, and thank you, committee members. My name is Maya Silak, and I am a criminal justice civil liberties fellow with the R Street Institute. And we are a nonpartisan, nonprofit public policy research organization that tries to advance limited government and free market principles, and appreciate the opportunity to testify in favor of SB 165 today. I know you've heard a great deal of testimony, so I'll keep this brief. Two things that we'd really like to emphasize that we think SB 165 would forward are, first, judicial economy and efficiency. We've heard again and again through the adult automatic charging system that 80% of these kids are sent back to the juvenile courts. That seems to be a huge waste of resources, judicial resources, prosecutorial resources, defense counsel resources. It makes much more sense to start these kids off in the juvenile courts, leaving open the opportunity always for the prosecutors to have absolutely the best opportunity to marshal the resources in prosecuting and directing their efforts against serious violent offenders. Secondly, the interest of public safety. Bottom line, we have overwhelming research. We've heard from the CDC, the US Department of Justice, that we know that channeling kids into the adult system leads to higher recidivism rates overall and increases in violent crime after the fact. And I think another thing to remember too, is that even where kids are prosecuted as adults, 95% of them are going to be coming back into the communities, right? That they're going to be coming back by the age of 25. And so the question then becomes, do you want them to have had rehabilitative services where they have a chance to turn their lives around, or do you want them to come out having been in contact with hardened offenders? And if you look at the statistics, you see that kids that went through the juvenile system versus kids that went into the adult system, those kids that went into the adult system have 34% higher recidivism rates. So we strongly support SB 165, and thank you for the opportunity to testify.
Thank you very much, Ms. Seelock. All right, next we'll go on to Ms. Berry, Professor.
Unmuted?
Gotcha.
Hello?
Yep.
Yes, okay, thank you. Again, I'm here to testify as a member of and on behalf of the Montgomery County Women's Democratic Club. And my name is Professor Margaret Martin Barry. Passage of this bill is, as with SB 53, a priority for WDC in this legislative session. We are heartened that the Juvenile Justice Reform Council recommends this change. Automatically charging children as adults is contrary to our obligation to protect their best interests. As others have said, this obligation is reflected in the numerous laws that we have, including the very existence of our juvenile courts. And that obligation, when it comes to even the most violent acts by children, calls for us to treat them in a manner that looks to care and rehabilitation, not to harsh punishment and abandonment. As Professor Henning emphasized in your briefing earlier today, placing children in the adult system has been shown to cause serious harm, such as increased risk of suicide, harm to identity formation, physical and sexual abuse at higher rates, being placed in solitary confinement, often for their own protection, without regard to the suffering and mental health implications. You might think we push children into the adult system because of the resulting societal benefit. Studies have found no deterrent effect in treating children as adults. Indeed, recidivism is increased, and the crimes post-incarceration are likely to be more violent. Furthermore, automatic charging disproportionately harms Black children in our community. Using 2019 data, the Office of Legislative Services calculated that Black youth in Maryland were over 7 times more likely to be criminally charged as adults than white peers. And the sentences imposed on these children were found to be harsher. Treating, educating, and rehabilitating child offenders is the responsible approach. Automatically imputing adulthood is as harmful as it is ineffective. Please pass SB 165 and vote it favorably out of this committee. Thank you.
Excellent. Thank you very much, Professor. All right, next we'll move on to, sorry, how do you? Mr. Johnson, you're up next.
Thank you very much, Mr. Chair, members of the committee. Thank you, Senator Carter, for bringing this important piece of legislation. My name is James Johnston. I'm a criminal defense attorney. I've appeared before this committee on this issue, both as representative of the Public Defender's Office and with the Department of Juvenile Services in the past. What I hope to do today is just to give you a practitioner's standpoint. I will tell you the Maryland Criminal Defense Attorneys Association, from legislative chair, supports this bill. I think the most important number that you heard today was 155 days. And that's the length of time that a young person spends in adult detention pending a transfer decision. Yet we know that 80% of those young people, either their case is dismissed outright or they come back to the juvenile justice system. That's 155 days before they even begin the juvenile case process. So that means trial, disposition, and then being sent to treatment. So that's 155 days. The current system doesn't work. We're really talking about 2 options here. We have a system with transfer as the primary option or waiver with the primary option. And this bill puts waiver as the primary option. You still have that option for circuit court judges when they hear particularly difficult cases with particularly challenged young people who pose a threat to the community, to send those young people into the adult criminal court system, the adult criminal justice system. Moving quickly, to me, is very important. It's important not just to the young people. It's important to crime victims, to police officers, to prosecutors, to resolve these cases in a much quicker fashion. It's the best option for everyone involved in the system, for all the stakeholders. The final thing I will say is that we dealt with the detention issue several years ago. It was controversial at the time, but for more than 6 years, every young person is presumed now, if they're transfer eligible, to be eligible for housing in a Department of Juvenile Services facility. That worked well. Maryland was at the forefront of that effort more than 10 years ago initially. Maryland has not moved on the issue of what offenses qualify for automatic exclusion. Now's the time to move on this. I've been practicing for many years. This is a perennial issue. We have the report from the council. We have before you a bill that would resolve many of the issues that we have in this system. It would get young people into the system, adjudicated more quickly, out of the system more quickly, to treatment more quickly. I would urge a favorable report, and I'm happy to answer any questions that the senators may have about how this would work from the standpoint, of a criminal defense practitioner. Thank you.
Excellent. Thank you very much, Mr. Johnson. All right, we'll now move on to James Dold. Is James still here? There you are.
Okay. Having a little trouble working my mute button. Thank you so much, Mr. Chairman, for the opportunity to testify before your committee again. James Dole for the record, representing Human Rights for Kids. I really want to center my remarks on this bill, discussing who these children are. I think so often we lose focus in talking about issues that sometimes in the abstract can, be boiled down to simple talking points. But the reality is when we look and we sort of peel the layers back of these children, what we find is that the overwhelming majority of them were victims of crime well before they ever committed any sort of offense. A DOJ study from 2014 found that roughly 90% of all of the children in the juvenile justice system had experienced at least 2 adverse childhood experiences, which range from everything from experiencing physical or sexual violence to coming from a home of neglect to having a parent who was incarcerated, extremely traumatic events in these children's lives, which then directed many of them to, join a gang or, hang out with the wrong crowd. Over 48% of those children experienced 4 or more of those adverse childhood experiences. And when we specifically look at girls, the numbers go through the roof. 73% of all system-involved girls were previously sexually abused. We call this the sex abuse to prison pipeline. When we look at youth in the foster care system, one of the numbers that jumps through the roof is that roughly 50% of them end up system involved, right? So these kids that we're talking about are kids who have come from just hellacious backgrounds. Now that is not to excuse the underlying behavior, but it helps us to understand that the environments, the home life, everything that's going on in these children's lives. I want to talk about a couple of quick cases that are high profile that folks probably have heard about before. Sarah Cruzan, Centoya Brown, Alexis Martin, Patrice Smith. These girls were child sex trafficking victims. This month is Human Trafficking Prevention Month. These were child sex trafficking victims who killed their traffickers and rapists, and then were automatically sentenced in adult court and given life sentences, right? Jared Harper and Daniel Corvibach is 2 boys who also killed their abusers, automatically sent to adult court, right? It's important to recognize that a lot of the kids that we're talking about have trauma histories, and juvenile court judges are in the best possible position to examine everything that is going on in a child's life and make the proper determination on whether or not that child should go to adult court, given all of the circumstances in those cases. When we look at other professions, nurses, pediatricians, teachers, everyone has specialized training on how they deal with children. We do that with juvenile court judges too, and that's why they're in the best position to make these specific decisions. I'll also just highlight one last case before I wrap up my testimony, even for cases like Kyle Rittenhouse, right? And I know many people on this committee are familiar with that case. That is another child who was automatically sent to adult court in Wisconsin. And I know that's a high profile case and it evokes a lot of emotion for different people on different sides of the aisle. But this is an example just to show that kids are at the mercy of a system that wasn't designed with them in mind. And it's why it's so important that we vest juvenile court judges with ultimate decision-making authority over these kids. And with that, we would urge this committee's favorable support for Senate Bill 165. Thank you.
All right, next we'll have Mr. Moroney. Mr. Moroney.
Yep, sorry about that. Just trying to unmute.
Oh, no worries.
Thank you, Chair. Good afternoon, almost good evening, and to you and Vice Chair and members of the committee again. And it's Nick Moroney for the record for the Juvenile Justice Monitoring Unit, which is the state independent juvenile justice monitoring office. And we're tasked with looking at and preventing problems within the juvenile justice system. What we've seen is, and we were founded basically as a unit on the back of systemic abuse 20 years ago. This is my 15th year as first monitor and then the director of the unit. We've seen tremendous improvements in the services and resources available to kids in the juvenile justice system. We also contribute to the transparency of the juvenile justice system in Maryland by producing public reports each quarter, which are on the web. They're available on the web through the Maryland Attorney General's website. There is no such monitoring unit for the adult system. There is nothing to try to ensure that there's any kind of appropriate services for adults in the prisons in Maryland, let alone kids who end up being in that system. There's very little transparency, and there's little or nothing for kids in that system. the automatic prosecution of children and young people in Maryland is a fairly recent invention, something that started to happen in the 1990s. And it does take away the balance afforded by court discretion to weigh allegations and charges and circumstances on a case-by-case basis when deciding whether to subject you to the adult criminal justice system. The vast majority of youth who are automatically charged as if they were adults do not end up in the adult criminal justice system, as we've heard. But in the meantime, they may be needlessly subjected to the risks associated with confinement through that system, which was ultimately found to be inappropriate. And we've heard of this 23-and-1. And just to reiterate for a minute what that is, it's for the protection of the kid, apparently, ostensibly. The child, if they're being held in the same facility as adults, have to be separated by sight and sound, and that's appropriate. It's a federal mandate from those adults who are being held. But how that's effectuated is by keeping them in a cell 23 hours a day, basically isolating them. So those are the kind of things, and I think Mr. Johnson referred to the 155 days. Those are the kind of things that are happening to the child, to the young person within that time. The adult prison system does entail high risk of abuse and self-harm. I'll just say again, if the current bill becomes law, it doesn't mean the end of prosecuting children as adults in Maryland, but it means that the court's right to examine charges and make decisions based on individual facts and circumstances is reinstated, rather than having an automatic decision based on a type of charge by an officer or prosecutor. Prosecutors will need to offer arguments to support turning a young person over to the adult criminal justice system, and that's entirely appropriate. And so for all of those reasons, the independent monitor supports Senate Bill 165 and would respectfully urge a positive report on the bill. Thank you.
Excellent. Thank you very much, Ms. Moroney. We'll now go to Mr. Oday.
Thank you, Mr. Chair. Again, for the record, Garrett Oday with the Maryland Catholic Conference and the Maryland Youth Justice Coalition. We're here to support the end of automatic charging of youth as adults. I want to thank Senator Carter for her persistence. We've been, I think I testified for this bill back in 2014, the first time, and we've seen other states pass this in the meantime. We've also seen a reduction in youth crime and crime overall in the meantime, but we continue to avail youth to the automatic charging of youth as adults. So relative to this bill, I just want to address the amount of time that passes between the initial appearance and a waiver hearing. When kids are charged as adults, for the 80% of kids who are ultimately moved to the juvenile justice system anyway, the average time before they merely get into the juvenile justice system is around 6 months. And when youth are charged as youth, as they should be in juvenile court, it's an average of 2 months before they get some finality. So what happens in those extra 6 months, I would ask, is education delayed? Are they denied treatment for the underlying issues that they may have in terms of mental health or substance abuse and everything else? So, and that's all on top of the stigma and exposure to the adult system that the statistics clearly indicate leaves them subject to recidivism later in life. That's on our state to not do better than almost all of the other states in the country. And what we can do here is fix the future. We just overhauled our education system in Maryland, which we supported to help our future generations. And an important next step is a restorative justice focus for youth in the justice system. I'll also say, as Senator Carter mentioned, in the United States, only Alabama sends more kids to adult court. So we're not asking for much politically, socially, what have you. Right now, the extra roughly 23% who might recidivate is on us and on our state. And if our system can be simply changed from a waiver down to a waiver up system, it might change the path of those youth in the future. Thank you.
Excellent. Thank you very much. All right. Is Mr. Megginson here? Mr. Megginson. All right. We'll come back.
He's here. I've asked him to unmute.
Okay.
I think he just unmuted.
Excellent. Oh, there you are. You're up next. Welcome.
Good evening, members of the committee. When I was 16 years old, I shot a guy in my neighborhood one time, forever changed his life. I'm so sorry for what I've done. For my horrible acts. I was tried as an adult and sentenced to 90 years in prison for attempted first-degree murder. My life was thrown away for what I have done. I was deemed unworthy of ever living in society again. But at the age of 16, I was not an adult. I was short-sighted. I was impulsive. I was a follower. I was a child. I spent my teenage years, young adult life raised in prison. I saw things no one should see. I experienced things no one should experience. It didn't cause me to be a better person. Prison does not help anyone become a better person. I became a better person despite prison. After spending more time incarcerated than I had lived on this earth free, I was given a second chance and I'm committed to making the most of it. I'm working, I cherish my family, I'm building a life for myself. The last judged me as an adult when I was only a kid. Nothing would excuse what I've done when I was a teenager, but I'm more than worth than I ever did at the age of 16. I was not yet a man I am today. The law should presume the children are irredeemable, even when what they have done may be unforgivable. But I ask that you end the automatic change of child as an adult.
Excellent. Thank you very much. And thank you for your patience all day. Excellent. Thank you. All right. Is Miss Blunt here? Terry Blunt. Sandy, do we have a Terry Blunt?
I don't think so.
All right. Move on to Donna Delasio. Nope. There we go.
Yep, just with that.
Excellent. Welcome.
It's not unmuting. There it is. Sorry. Thank you very much. My name is Donna Delasio, and I'm an attorney with the Office of the Public Defender. I have been representing children charged in adult court since 2003. The commission of a violent crime does not transform a child into an adult. What it does is transform a child into a child who is in dire need of intense, comprehensive, individually targeted, and evidence-based rehabilitation. This cannot be provided in adult court. We all know that the science shows that the adolescent brain differs from the brain of the adult in ways that seriously affect crime, justice, and rehabilitation. We also know that trauma further inhibits brain function. The good thing about the adolescent brain, though, is that because it is undeveloped, it is also highly malleable and quite receptive to rehabilitation. I see kids on a daily basis with immature, traumatized brains, little financial security, no recreational space, kids who love their families but are often with little supervision, find themselves on the street, almost always in a group of peers, seeking, like all teenagers, emotional and social gratification, and unable to stop, think, and consider before they act. I do not see kids who take from others without giving, who have a lack of empathy or remorse, who are unkind or disloyal, or who have deliberately chosen a life of crime. Public safety is about rehabilitation. It's not about time. The solution you hear from most prosecutors is that we should keep these kids in adult court and just send them to Patuxent. They act under the assumption that Patuxent Youth Program The children will be there longer and have more treatment, and they will be fine. This is categorically untrue. Pituxent is wholly inappropriate for the rehabilitation of children who have been charged as adults. First of all, minors don't go to Pituxent, they go to YDC, which is a facility with no treatment. Secondly, when they finally get off the wait list and end up at Pituxent, they spend a 6-month evaluation period during which most of them are rejected.
Time.
In addition, there's no individual treatment and no focused therapy at all, no trauma focused therapy at Pituxent. In contrast, DJS programming is comprehensive, evidence-based, and developmentally appropriate. DJS can provide the rehabilitation that the adult correctional system cannot. For those whose rehabilitative needs cannot be met through the juvenile system, state need only file a waiver petition. It is this body's responsibility to provide for the public safety and the welfare of our children. I encourage a positive report on this bill. I'm also available to answer any questions if there are any based on the public defender's response to the Harford County memo. Thank you very much.
Excellent. Thank you very much. All right. Is Miss Egan still here? I have her on the list, but I know she's already offered testimony. I don't see her in the room, so we'll skip back to her if she comes back. All right. Ms. Henning, you are up.
I don't see her in the room.
Got it. All right. What about Christopher Wilson? Is Christopher Wilson here?
Also not in the room.
All right. What about Terry Ocampo?
Yep.
Mr. Ocampo, Miss Ocampo. There you are. Welcome.
Thank you. I wanted to speak today in reference to the bill. My name is Terry Ocampo, and I'm impacted community member because my 17-year-old son was charged in adult court last year. This experience has been immensely painful for my family. I'm a veteran of the United States Army and currently work in law enforcement. I used to think that if you commit a crime, you should be punished. Didn't matter if you were a kid or not, but then it happened to my family. This experience has made me realize that even good kids get caught up sometimes. Kids who get in trouble aren't bad kids, but they are kids. They should be given a chance to learn, even if they have to learn through their bad choices. My son is not a perfect kid, but he has always tried to be a good son, neighbor, and friend. He's always tried to help out in the community with yard work and little details around houses with neighbors. As a parent, you think that once your kids start getting older, they don't need you as much, but they're still learning how to move in the world and avoid the negative influences around them. My son wasn't able to avoid all the negative influences. Thank you.
Excellent. Thank you very much. Ms. Tavares, I see you're still here. Did you want to, are you still want to testify? Okay. Let me unmute you here.
I do, and because I have to get going. I'm sorry.
No worries. I thought you'd already.
I know that we had a little bit of a snafu where I came in and testified for the wrong bill, and so you've heard what I had prepared originally, but what I wanted to just add some data that's pertinent to Prince George's County, primarily that 9 out of 10 children's charged in adult court do not result in adult criminal conviction, but that these children will spend time in adult jail before transferred to a DJS facility. And we know that the harm of these kids in adult jail prisons, they're the targets for violent sexual assault and exploitations. And so they're 30, and we've heard the number that they're 36 more likely to commit suicide and a greater risk of sexual victimization. So, and the fact that they've also had to trade their commissary and food for safety and many psychiatric medicines used to treat underlying mental health disorders are barred, as we mentioned, in these adult prisons. I also and I think we heard about the 155 days, but I also wanted to say that, and share a little bit of my personal story at this point, because I hadn't had an opportunity to share. John King and I almost went to school together, literally. And he and I have to say that we commiserate. I had lost my mother by the time I was 4 and to suicide. And my father, who was the taxi driver, as I previously mentioned, was killed by the time I was 8. And as an Afro-Latina, I too could be any one of the statistics that you're looking at and considering today. So what I have to say is that I stand before you today before the grace of God. I too have been prosecuted in the state of Maryland, I wouldn't be the success that I am today. And to me, at the end of the day, this is a cost issue. This is a cost issue that where a favorable decision by you all will save us money, resources, and result in a more favorable societal outcome overall. And this is not just
time
policy. This is not just smart policy, but the right thing to do, because it lets kids be kids. And so with that, I say thank you. Thank you for giving me a second chance to testify on the correct bill this time. And I just want to say, please, I ask for a favorable report on SB 165. Thank you all very much and have a blessed day. Bye-bye.
Excellent. Thank you very much. And thank you for being patient with us. All right, we'll now move on to Gypsy Allen. Gypsy Allen here.
I do not see Gypsy.
Okay. Mr. Culver, Alan Culver. Just as a note, we've now switched to the opponents of the bill. Welcome.
Mr. Chairman, good evening. Members of the committee, good evening again. My name is Alan Culver, and once again, I'm the state's attorney for Carroll County. I'm here to testify in opposition to Senate Bill 165, juvenile court jurisdiction in its current form. Not every crime committed by a juvenile is appropriate to be centered around rehabilitation of the juvenile. The most violent of criminal offenses committed by juveniles requires a more balanced approach that includes considering the rights of the victims and the safety of the community. When cases begin in the adult system, there are additional resources available to ensure the safety of the community, which are not available in the juvenile system. Numerous mechanisms are already included in the current process to protect juveniles, and you've heard about many of them today. Age requirements for initial charging, transfer hearings. Juveniles can have bail reviews in front of a judge the next day to determine if they're eligible to return to the community. And even after conviction, the juvenile may request a review to determine if the case should be remanded to the juvenile system. There's a misconceived perception that a large number of juveniles charged as adults are of very young age. However, between 2013 and 2020, an average of 975 juveniles were charged with automatic adult offenses. Of those 975, 95% of them were 16 to 17 years of age, and 61% were 71 years of age. Lately, there's been a movement to close and eliminate juvenile detention facilities, and many of these facilities needed to be closed. However, no juvenile facilities have been developed to replace the ones that were closed. Eliminating adult jurisdiction will cause violent juvenile offenders who may be more appropriate for an adult detention facility to be housed in already overburdened, overcrowded juvenile facilities with other juveniles who will be in danger. Eliminating adult jurisdiction entirely will have a ripple effect across the criminal justice systems. Whatever the problem may be, there are ways to correct the problem without preventing juveniles who commit murders and rapes from appropriately being charged as adults. I urge an unfavorable report on Senate Bill 165 in its current form, or request that this matter be tabled for further discussion to see if an agreement can be worked out to allow certain crimes to remain as automatic adult jurisdiction for juveniles. Thank you.
Thank you very much, Mr. Culver. All right, we'll go. I messed up and went out of order. Mr. Nally of the ACLU should have been the last for the proponents, so my apologies for that. But in order to keep my promise to Mr. Potashnik, he's going to go first. So, Mr. Potashnik, you are up.
Thank you, Mr. Chairman. Mr. Chairman, Mr. Vice Mayor, members of the committee, first and foremost, again, my name is Gavin Potashnik. I'm Deputy State's Attorney for Hartford County. I do want to thank Senator Carter for bringing this to everyone's attention so we could have this very important discussion. However, we are asking for an unfavorable report with respect to this legislation. I did write a rather lengthy memo, which I think everyone has a copy of, and that I stand by every word with respect to that. And I really do wish I was a part of the discussion you had before this bill so I could provide a counterbalance to what was presented there. However, just to kind of bring two highlights with respect to what I wrote. One, the 155 days. I think it's important for the committee to note that the 155 days and variations on that was something that was studied by the Department of Juvenile Services a couple of years ago. And they discovered once they dissected the process that many of that 155-day delay was due to the Public Defender's Office postponements because they were getting experts to defeat the state in those types of transfer hearings. So it's not just a straight 155 days or 125 days. Much of that was due to public defender and defense attorney delay. Secondly, I want to highlight the fact that waivers and transfers are completely different proceedings. They have different burdens, and they have also different persuasions. So in a transfer, the court must be persuaded by preponderance that transfer of jurisdiction is in the interest of the child or society. That opens the door to many different types of discussions and topics. However, in a waiver, the burden falls on the state, and we must prove that the child is unfit subject for rehabilitative measures. If we rely upon the Department of Juvenile Services to provide the only report with respect that the state can use, how can a court not conclude that there must be something for a youth to hold on to so that they could be have some sort of rehabilitative measure? That standard is not a good standard for the state. And I will tell you, I've practiced juvenile law for many years. I was the chief of the juvenile division in Baltimore City. I have done countless waivers. I've done countless transfers. I have practiced in this arena both as a prosecutor and as a public defender. Both as a prosecutor and as a private attorney. And I will tell you that waivers are very, very difficult to win because of that standard. So it's not a simple burden shifting. It's not a simple, well, let's let the state do it. They are two different animals. And as a result, you are going to have a lot more youth being tried in the juvenile system. You are going to have a lot more youth being subject to that. And whether that's what this committee wants or not, that is up to you. But I would challenge anyone to say that there isn't a population of youth who do crimes which should belong in the adult system because of the nature of them. And that includes murder, rape, carjacking, and some others. So with that, Mr. Chairman, I appreciate the not going last, and I ask for an unfavorable report.
I appreciate that. Thank you for that. And that's on me for the earlier today not being incorporated, but I promise you'll have a seat at the table on the as we work through the legislation. All right, Mr. Naylor, you're up. Sorry. All right, finally.
Great, thank you. Good evening, Chair, members of the committee. Justin Nally with the ACLU of Maryland. We come to you today in support of SB 165. I concur with all the colleagues beforehand that talked about the data of the disproportionalities of why you should start in juvenile court. I think we should follow the recommendations of the Juvenile Justice Reform Council to end automatically charging children in adult court. With that, the ACLU of Maryland urges a favorable report for SB 165. Thank you.
Excellent. Thank you very much. All right. Now, Senator Carter, I see you have a question, but we've finished our testimony unless I've missed someone. So, Sandy, I think we had a lot of witnesses today, and I think I've got everyone. So if there's an oversight, let's raise it now, and then we'll move on to questions. But I think I've gotten everyone.
I believe you have.
Excellent. All right. Now, so that concludes the testimony for what Senate bill is this? 160.
165.
165, and we'll now move on to questions from the committee. And Senator Carter, you are up. Sorry, hold on. Go ahead. There you go.
Thanks, Mr. Chair. I know the hour is late. I'll be really quick. My quick question is for Attorney Potashnik. You mentioned this idea that the reason for delay is often the public defenders or the defense attorneys are requesting continuances to get expert witnesses, expert reports and testimony. But isn't that necessary for them to do in order to be able to convince the court that the case should be transferred?
So the Davis court made it a recent phenomenon where amenability and whether or not a youth had a condition that would lend itself to rehabilitation is now basically the standard. And the Davis court made that amenability the central factor of the 5 factors. But having done this for many, many years, I've had defense attorneys not do any studies. The defense attorney employing an expert is a recent phenomenon that was actually pioneered by Mr. Johnson a couple of years ago. And so using that experts was not something that was even done for many years. It's only recent that it was done. And once that occurred, then the postponement started to happen. I practiced back in 2007, through 2010 in the juvenile division as a line ASA doing transfers. And at the time we had a neutral party called CMAT who used to do a report, and that was it. And we would have those transfers done pretty quickly. So that's the reality.
Well, that's not my understanding, because I've heard from others that if the reason that they have to get this these reports and this testimony is because often the state's attorneys will not agree to it. And so they're forced to put on the case and they have to put on the strongest case possible, which makes sense. So maybe if the attorneys were more willing to agree to consent to the transfer and waiver, that might not be necessary. The other thing, gosh, I think I might have almost forgotten my other question. Oh, it's more, my opinion, and I'm sure you're going to probably dispute me on this, but, everybody likes to raise, certain most, notably egregious, heinous cases like the 13-year-old case of Nick Browning. Isn't it true that in those kinds of severe cases, you would not have difficulty meeting a burden, most likely to put this in adult court, even if it started in juvenile?
Oh, thank you. So that is an excellent question, Senator Carter. And the Davis case really throws a lot of uncertainty with respect to that. I think previously to the Davis case, when all 5 factors were considered kind of independently of one another, I think you could be right, maybe. I think now that the Davis case is kind of centralized, where the standard from them essentially is whether there are programs available to the specific needs of the defendant, whether the defendant would be benefit from the available programs, or whether that would reduce the likelihood of recidivism and make the person a more productive law-abiding citizen. That, I think, has become the standard, because amenability is now the central factor, because the Davis court has rolled all the factors into that. So, it remains to be seen whether a court utilizing the law itself will have trouble looking at the crime only and saying, well, then I can't do it. Yeah, potentially. But I think that amenability factor and that expansion of that makes a waiver much more difficult. I'd also add that, yeah, Nick Browning was a terrible case, but there's a continuum of murders, some very terrible that you never hear about, and some that are not so terrible that you also never hear about, where this centralized factor would effectuate those cases as well.
Thank you. I think that the court in Davis, though, gives us guidance as to what the Supreme Court of Maryland wants to see us do in a lot of these juvenile cases. So thank you for your testimony. And I appreciate the fact that you appreciate my sponsoring the bills. And, you know, I'm looking forward to working with you. Thank you.
We appreciate you, Senator Carter. So there we go. All right. With that, if there are no further questions from senators, that will conclude the hearing of Senate Bill 165 and our hearings for the day. Thank you all, to the witnesses, to the panelists, and to the senators for your fortitude here. Tomorrow morning, we have a voting session at 9:30. All right. Have a good night. See you all later.